Sorry to trouble you, Lordship, one letter for tomorrow, not today. Yesterday we filed. Yesterday we filed. It's a contract from 18th of January. Then then we have given pledged also a fixed deposit which is secured. Thereafter we say we'll pay the bank guarantee. There was some fault in the bank guarantee. Ultimately fixed deposit is them. We supplied also. But they have decided there's something wrong with your bank guarantee. That's why we have decided to annul on 38th. So we have filed yesterday. I don't want trouble. Please, my lord, just request your lordship can go through the petition. That's why I'm requesting that tomorrow the matter if it can be taken. Three matters. Sorry for troubling.
Three matters.
No, say it's arising out of this three package,
New matters.
new matters. I'm
Okay.
deeply organized. I'm deeply organized.
May I please your lordship, I beg to mention for listing. So matter may become up admission on 2nd of December. Non-payment.
No,
of
no,
affidavit
not
is-
second.
Applies.
Read to the lordship. Regarding item number 2, my lord. I have returned a brief for some personal reason. So, my lord, at least after 2 weeks, my lord, so that they.
You have
can give
returned the
the-
brief.
I have returned the brief.
Right. Mrs. N. Saikia, learned counsel for the petitioner submits that she has returned the brief to the petitioner. As such, Mrs. N. Saikia, Mrs. P. Goswami, and Miss L. Borgohain will not be appearing for the petitioner any longer. So they are going to engage some other persons.
Yes, my lord, I have told them, but he is in Delhi and in hospital. So, my lord, 2 weeks time may be given so that he should come back and engage other.
As such, the petitioner would most probably be engaging a new counsel. This is the matter after 2 weeks.
Right.
But I'm praying for listing of this matter for withdrawal tomorrow. May I please your lordship. So I beg to mention item number 10 and 11. JMC has filed a affidavit opposition. We may be allowed to file rejoin affidavit lordship. And it may be fixed on 6th of, as we have agreed.
Time for as per number 3, there is a stage of item.
On 6th only, yesterday they have filed. I've got a copy yesterday. So maybe on 6th, maybe for the
You'll be filing a reply,
reply, yes, lordship.
Mr.
D. Decca, lordship.
D. Decca, learned counsel for the petitioner. Submits that affidavit in opposition has been filed by the GMC
Item number 10, 11, they have.
yesterday. He accordingly needs time to file affidavit in reply. He also prays that the matter may be listed on 6th.
6th, lordship. 10 and 11.
List the matter on 6th.
Like that. 10 and
Are you filing anything, Mr. Bolthakur?
I will realize the affidavit filed with the JMC.
like.
Actually, it is right. Mr. L. Bolthakur appearing for the private respondent submits that no affidavit will be filed by the private respondent and they will be relying upon the affidavit filed by the GMC.
At this is the.
Huh?
At this is the.
Actually, at this stage, what are the stages there?
I plead your lordship. Lordship, I beg to beg for listing of a matter on Monday, your lordship.
Monday, what new matter, old matter,
No,
what?
no, your lordship, it's a matter of 2018, your lordship.
give a date.
Last 20, from last 2 years, the matter has not listed.
Not Monday, not Monday.
Court of lordship.
I think one for.
Huh?
No, please, Your Lordship. Lordship is taking up this matter for final disposal. So I'd like to place the facts first. The petitioner before your lordship
is a joint venture entity which has participated in the tender for hiring of an entity for removal of overburden and extraction and transportation of coal from Tirap to Tirap Colliery under the Coal India Lordship. That tender notice is at page 51.
NIT of 5/7/21.
5/7/2024. The relevant provisions of this NIT, Lordship will find at page 60, Annexure 3, in the column of additional terms and conditions, instruction to bidders. So clause 2, eligible bidders. The invitation for bids is open to all bidders, including an individual, proprietorship firm, partnership firm, company registered under Companies Act, or a joint venture consortium. The bidders shall be eligible to participate only if they fulfill the eligibility criteria specified in the bid document. Additional terms and conditions in a tender. A bidder shall participate in one bid only. I am concerned about 2.2. We are a joint venture entity. So joint venture / consortium, 2 or 3 companies, contractors may jointly undertake contracts. Each entity will be jointly and severally responsible for completing the task as per the contract. Joint venture consortium details: the lead member, the minimum participation share is 50%. The members should be 20-20. Joint venture must comply the following requirements. The JV consortium must enroll in the name of lead partner on behalf of JV consortium for bid submission on GEM portal. So there is no dispute on this clause number. Clause number 2. The qualifying criteria parameters, example, experience, financial resources of the relevant period, and the equipment's fleet strength of the individual member. Lordship will kindly mark this: individual member of the JV consortium will be added together. This is also very relevant, Lordship. And the total criteria should not be less than as spelled out in qualifying eligibility criteria as specified in the additional terms and conditions bid document. However, the required working capital shall be made by the individual members of JV as spelled out in the relevant clauses. Then Roman 4, the bid, and in case of successful bid, Lordship will kindly mark this: the bid, and in case of a successful bid, the agreement shall be signed so as to be legally bind on all members jointly and severally. And any bid shall be submitted with a copy of the JV's consortium agreement, providing the joint and several liabilities with respect to the contract. So in case I am a successful bidder, then I have to give an additional contract agreement amongst the 3 partners. This Roman 4 is very relevant from that perspective. Then Roman 9, next page. The contract agreement should be signed by each JV consortium members. Subsequent declarations, letters, documents shall be signed by lead members authorized to sign on behalf of the JV consortium or authorized signatory on behalf of the JV consortium. So there are scope for subsequent agreements also, subsequent documents also within the terms and conditions of this tender. Roman 12. The JV consortium agreement may specify the share of each individual member for the purpose of execution of this contract. This is required only for the sole purpose of apportioning the value of the contract to that extent to individual members for subsequent submission in other bids, if he intends to do so for the purpose of qualification in that bid. So this is also very relevant. Now Lordship will kindly come to page 70. At top, legal status of the bidder. Sorry. 64. Lordship will kindly come to page 64 also once. These are part of clause 3 eligibility criteria of the bidder. It starts from page 62. Eligibility criteria of the bidder.
Where, 64 or 62?
It starts from 62. Eligibility criteria of the bidder.
Where,
Then Lordship will kindly come to page 64, last one. In case the bidder is a joint venture consortium, the work experience of anyone, 2 or 3 of the individual members of JV consortium or the JV consortium itself may be furnished as the work experience of the bidders. So individual credentials may be submitted. Now coming to page 70. Legal status of the bidder. The bidder should be individual proprietorship, partnership firm, company registered under the Companies Act Joint Venture Consortium. So there's a single status of the bidder. There is no individual status. Then information to be furnished in bid submission confirmation sheets that Lordship will kindly come to. There is one clause at page 72. R. Documents as required to comply with order dated so and so for preference to make in India applicable issued by Government of India amended from time to time shall be submitted. In terms of above said policy, purchase preference shall be given to class 1 local suppliers. Now coming to page 79.
so it says here class 1 local suppliers and class 2 local suppliers can also.
Yes, so there should be a certificate that we are going to purchase local from the local suppliers.
Is there a percentage of the
Yes.
Make in India product?
Yes,
How much
there
is, how much?
There is a percentage. A.
There,
Class 1 local supplier means a supplier or service provider whose goods, services, or work offered for procurement has local content equal to or more than 50% as defined under the said order. Then class 2 is 20%.
more than 20%,
Yes.
less than 50.
So now coming to page 79. We have to repeat to these clauses later during my arguments also. I'm just giving an overview of the overall scheme of things.
Page
Clause
70.
19, evaluation of tender. After opening of tender technical bid, as the case may be, it will be evaluated by the constituted tender committee. Evaluation of tenders 19.2, I am coming to Roman 2B. In case the tender committee finds that there is some deficiency in uploaded documents corresponding to the information furnished in the bid submission confirmation sheet, or in case corresponding documents may have not been uploaded by bidders, then the same shall be specified online by evaluator, clearly indicating the omission/shortcomings in the uploaded documents and allowing 7 days, 7 into 24 hours time for online resubmission by bidders. Additionally, that is also important. Additionally, the information shall also be sent by system generated email and SMS, but it will be the bidder's responsibility to check the updated status information on GEM portal regularly after opening of the bid. No separate communication will be required in this regard. Non-receipt of email and SMS prescribed will not be accepted as a reasons for non-submission of documents within the prescribed time. The bidder will upload the scanned copy of all those specified documents in support of the information declarations furnished by them in the bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from the bidder. The shortfall information document should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not undergone change since then. So when additional documents has to be called for Lordship, it should be with the original records, historical records,
Only historical documents.
historical. This should be called on basis of the recommendation of the technical committee. So far as the submission of document is concerned with regard to qualification criteria, after submission of the tender, only related shortfall documents should be asked for and considered. For example, if the bidder has submitted a work order document relating to a particular contract work without its completion performance certificate, the certificate can be asked for and considered. However, no work order for new contract should be asked for so as to qualify the bidder. It is making it very clear. So whatever work or whatever credentials I have prior to the last date of submission of the tender, lordship, if there is any shortfall regarding submission of any supporting documents in respect of those materials, that can be called for. But no fresh materials, no fresh credentials can be added. F. Seeking technical clarification shall be restricted to confirmation of submitted documents information only, and it should only be one time for a period of up to 7 days. The clarification shall be taken in online mode in the e-procurement portal of GEM only. H. In case bidder fails to confirm the submitted information declaration by the submitted documents as be above, his bid shall be rejected. However, if the confirmatory documents do not change eligibility status of the bidder in connection his submitted information declaration, then his bid will be accepted for opening the price bid. This is also very important, lordship. If the confirmatory documents do not change eligibility status of the bidder in connection with his submitted information, that means already submitted, then his bid will be accepted for opening the price bid. Now coming to clause 22, page 88. So there is a handle given in their additional terms and conditions, lordship. Examination of bids and determination of responsiveness. A substantially responsive bid is one which conforms to all the terms, conditions, and specifications of the bidding documents without material deviation or reservation. So there is a scope that they themselves has indicated that if a bid is substantially responsive, then it has to be accepted. Now, what makes a material deviation? A material deviation or reservation is one, A, which affects in a substantial way the scope, quality, and performance of the works. So that can be a part of, that can be considered as a material deviation. B, which limits in any substantial way, inconsistent with the bidding documents, the employer's right or the bidder's obligation under the contract. And C, whose rectification would affect unfairly the competitive position of other bidders presenting substantially responsive bids. 22.2. If a bid is not substantially responsive, it may be rejected by the employer at its sole discretion. So that authority is with them. Now, to reject the bid, it has to not comply the requirements substantially. And what will make a substantial or material deviation, that has also been prescribed under the terms and conditions. They have also given a format, page 107. This is a pro forma. One of the condition is that my joint venture agreement is not in conformity with this pro forma. 3 or 4 additional words I have inserted. That is the basic case. So annexer to pro forma of joint venture consortium agreement. This is given.
Page
107, lordship.
performer, yes.
Yes.
Annexure 2.
Annexer 2, lordship. And the relevant portion will be page 108, next page, lead partner. I'll come to this clause a little bit later, but this is a lead partners clause. The wordings are there. Whether the lordship will have to compare my joint venture agreement vis-a-vis this, what is there in the pro forma. I have given the distinction. And next page 109, joint and several liabilities. All partners of joint venture consortium shall be liable jointly and severally during the pre-qualification of the bidding process and in the event the contract is awarded during the execution of the contract in accordance with the contract terms. So here also, there is a future event which has been contemplated. What is that contemplation, Lordship? In the second part of this 5, in the event the contract is awarded. That means if I get the award during the execution of the contract in accordance with the contract terms. So the elaboration will be a little bit later. And the previous page, Lordship, will kindly come to the previous page. What the lead partners clause says. MS so-and-so shall be the lead partner of the joint venture consortium and is in charge of performing the contract agreement management. MS so-and-so shall be the attorney of the parties duly authorized to incur liabilities and receive instructions for and on behalf of any or all partners in the joint JV consortium and also be partners of the JV consortium shall be jointly and severally liable during the bidding process and for execution of the contract as per contract terms with the employer. All joint ventures consortium partners MS so-and-so, 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 nominated or authorized so-and-so to sign all letters, correspondent papers, certificates, and to submit pre-qualification application bid documents for and on behalf of the JV consortium. So, in terms of this tender, terms and conditions as well as the main tender document, Lordship, we have submitted. The last date was sometime in the first week of August, that is 5th.
Just a minute, last date of submission of bids.
Yes, Lordship. That figure I'm giving, that date I'm giving. Page 57, Lordship. There is no dispute regarding this. The time schedule is given there. Exact date was, if I'm not wrong, it is 5th of August. I'll confirm it, Lordship.
5th of August, 2020.
4. On 16th, because under one clause, if there is any shortfall found by the tender committee, they can inform us. That information I have received.
That would be at the time of the consideration of the technical bids or
No, at
prior to that?
technical, yes, technical.
at the time of consideration,
Yes.
evaluation of the
Evaluation, they
technical.
will evaluate and they have informed us.
Okay.
And
So-
everything
so-
is in the portal.
So the technical bid was opened when?
Technical bid was opened. That information they would have to give, Lordship, because we are not privy to that. It was done internally.
Okay, then you were informed that
Yes,
some
there
there was
is
some
shortfall.
shortfall. Where is that letter?
That letter is at page. This is of page. Page number is 198. We have to look into the portal, and the portal, this screen is shown.
Correct.
This is the screenshot. Highly technical now it is, Lordship. Yes, there are 3 requests from below, Lordship will start. Request number 1 at the
Ah.
lower part.
Yes,
Type undertaking affidavit. You are requested to submit the certificate in the name of JA so-and-so, 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 issued by the practicing
a cost
cost
accountant.
accountant, practicing chartered accountant regarding local content as per Annexure Roman 9A of the ATC of bid document. So this, they wanted that it has to be submitted in the name of the JV. Earlier, what we have given individually. There are three constituents of the JV. It was given in their name, 100%, 50-50 like that. Now they said that in the name of the JV, you have to give. So this information was of 16th of August.
Yes.
On 17th, we have submitted those documents. I will come to those documents.
So all three of them have been submitted. Number two is what? Number two
Number
is,
two, you are requested to submit a clearly readable copy of partnership deed of MS Dave Mining Company. So one of the constituent is Dave Mining Company. Their partnership deed also is required. So it was not legible. So they wanted a clear or legible.
this MS Dave Mining Company is a partnership.
Yes. Is a
It's
one
a
of the
partner, it's a partner of the JV.
of the JV.
It's otherwise it's an individual concern.
Is an individual concern also.
So your JV is made up of three partners.
Three partners.
Then the
Then
type,
at request number 3. Additional documents requested in ATC due to text limit by the GM portal, the query is attached.
so where is this?
Where is this? That is the question, Lordship. That is the question to us. Where is this? According to them, it is there. We could not find it. And we cannot communicate with them. Under the tender conditions, I have placed already clause 19 that there is no individual communication. Whatever communication is to be made, it is through the portal only.
Okay, so this request number 1 and 2,
We have complied with it.
you have answered it on the next day itself.
On the next date, there are two grounds why it was rejected.
No. Anyway, request number 1 and 2
We
were
complied
answered
on next day,
on
17th.
17/8. So now they've got no problems with request 1 and 2.
They have a problem.
Is there a problem?
They have a problem. The problem is very simple. They asked us that instead of individual, this certificate of local content, you give it in the name of the JV from a certain accountant or cost accountant. So we have to procure that
Correct.
with the same contents, same credentials, same qualifications, same experiences, Lordship. The date of the phase certificate is after 16, that is on 17th.
Yes.
But we have to think that whether there is any change of the historical data, whether from 16 to 17 there is any change, or from 5th August to 16th of August there is any change. No.
No, but where does this requirement of submitting this undertaking affidavit,
Yes.
is there a performa undertaking or affidavit provided in the
No.
NIC?
So far as this is concerned, no. But law is well settled, Lordship.
So, no, I just wanted to know.
Yes.
So according to you,
Yes.
there is no performa, or there is no format,
Local content
provided.
pro forma is there, Roman 9A ATC, 128.
page.
128. This is the format. Format so page 128 is the format. Earlier, this format very clearly says, I'll place the format, what we have submitted. Certificate of local content as per public procurement order 2017, tender so and so. I statutory auditors of cost sharing. He gives his certificate. And he gives his certificate individually to all the three components of the JV or entities of the JV. That Lordship will find at page 199, next page. Oh, sorry, page 200. So the chartered accountant Arvind Kumar gave this certificate in favor of MS Jai Ambe Road Lines Private Limited, previously known as Jai Ambe Road Lines, so and so Jogendra Singh. That is one. And here,
So this is one of the partners.
one of the partner, and the 50% is there down below, Lordship. The last same page 200, 50%. The next is, Lordship, page 200A, Annexure 6. Sorry, it's just a 201. This is of 12th July it is 100% and meets the local content requirement. 3 lines in the first, from below in the first
This
panel.
is the same, this is the same, Jai Ambe Road lines.
No, it is little bit different. It is will 201.
201.
To A, that is the type copy at,
JPW Infratech.
yes. This is a lead partner, he fulfills 100%. Then Lordship will kindly come, yes, so 2 we have given. So
Sure.
one partner gives 50, the
But
other
you,
partners give 100,
but you have 3 partners.
3 partners, that is not required. Because we fulfill, the requirement is 50% only,
Okay.
only 50%. So we have 150%. Here. So regarding the eligibility criteria, regarding the quantum, that is not the issue. Now, after this 16th letter, we have submitted a fresh certificate at page 199.
This is with regard to the Make in India part,
Yes,
the local content.
yes, Lordship. That all these things will come later once the bid is finalized, page 199. So after that request letter, which showed the shortfall at page 1 there, we have submitted it. Lordship will mark the date 17th of August,
Where?
page 199. 199.
199.
Now Arvind Kumar, the same chartered accountant, gave this certificate in the name of the consortium of JPW DMC. So here, his certificate is more than 50%. So that fulfills the requirement. But the issue is not the quantum, not the entity, it is the date. This late sub certificate should have been issued prior to 5th of August.
Historical.
Historic. But whether there is any change, there is no change. And this is within the scope, within the parameters of the additional terms and conditions. It has not changed the eligibility criteria or the credentials of any of the entities as well as the JV at any point of time. They want a clarification that your certificate was issued individually to 2 of the components of the JV. They said that give it is in the name of the JV's name.
It should have been in the JV's name. It was not done in JV's name.
JV's
That's the basic thing.
But that is also not required. As per the eligibility criteria, Lordship will kindly come
It can be done individually.
individually. That is there.
But then the format, the format at page 128, what does that require?
Format, the format is Lordship 128. Here, both the options are there. We practicing so and so the statutory auditor, cost auditor practicing so and so have registered office, confirm that the percentage of local content of the offered product service of MS so and so is dash percentage and meets the local content requirement of class 1 local supplier as prescribed under the Assam Public Procurement Order 2017. So there is another option. That is the class 2. We are in class 1. So first part is applicable to us. So here, if the JV is the
Okay, so where is the clause requiring that one of the partners affidavit or certificate is enough?
yes, that Lordship will kindly come to the eligibility criteria. Page 60. The qualifying criteria. 2.2. Roman 2. Maybe.
Two point
2. Roman 2, Lordship. The qualifying criteria, Lordship, have noted. The qualifying criteria parameter example, experience, financial resources, and the equivalent fleet strength of the individual members of the JV consortium will be added together and the total criteria should not be less than the spelled out in the qualifying eligibility criteria as specified in additional terms and conditions. However, the required working capital shall be made by individual members of the JV as spelled out in the relevant clauses. So there is a scope for addition of all together.
No, the qualifying criteria,
And this is in requirement, Lordship will come, few
Yeah.
lines above, joint venture consortium must comply with the following requirements. So this is in respect of the JV.
correct? No, now as for 128, you are supposed to give this is a format for local content.
Format for local content. So
And this 2.2 point Roman 2 provides that the qualifying criteria experience, finance resources.
instead of the individual members of the JV,
But this does not talk about local content.
all example they has given the experience, financial resources. These are example they have given. The qualifying criteria includes 50% local content,
No, I want this page 128.
Lordship.
It is relating to which clause?
This is relating to the local content clause, Lordship. I'll just page 19, I think. Clause 19. Just 1 second. Yes. Clause 19B.
No, page.
Local content. Just 1 second. Local content. Yes, page 72, Lordship. Page 72, it comes within the scope of the eligibility criteria. Page 72 down below. In terms of the above policy, purchase preference shall be given to class 1 local suppliers. In terms of the above said policy, class 1 local suppliers and class 2 local suppliers shall be eligible to bid. Definition of class 1 local supplier, class 2 local supplier, non-local supplier, local contents and margin of purchase preference as per above mentioned order are as follows. A, class 1 local supplier means a supplier or service provider whose goods, services or work offered for procurement has local content equal to or more than 50% as defined under the said order. So here, what we have said, 100% in one case, the other, if you divide that also, it will become 50%. So first two will cover that. But now they want that it should be in the JV's name. So we have given the certificate which we have given, it is 50% in the name of JV.
Just a
And-
minute, just a minute. 72.
Equal or more than 50%.
So as per this, clause this page 72
Lordship.
comes within clause 3 or what? Which clause? Clause 3.
Main clause will be Lordship. It will
3.1.
yes. Three will be Eligibility criteria of the bidder. Page 60, it starts. 62, Lord. Eligibility criteria of the bidder.
No, my question is basically this local content.
Yes, Lord.
It does not say that the affidavit has to be filed by all the, on the name of all the three partners, does it?
Neither it has been said by three partners, nor
Or
it has
by
been by the
individual?
JV, individual. So therefore, we have to come to page 60 regarding the joint venture eligible bidders. Who can be eligible bidder? Clause 2. So clause 3 is eligibility criteria, clause 2 is eligible bidders. So when we saw that who can be eligible bidder, there are various options. One is individual, one is proprietorship firm, one is partnership firm, one is company, or a JV. So this JV was constituted in terms of this tender notice. And 2.2 says joint venture consortium. Two or more companies, contractors may jointly undertake contracts. Each entity will be jointly and severally responsible for completing the task as per the contract. And for the composition of the JV will be lead member 50% share, members will be 20-20. Joint venture consortium must comply with the following requirements. I'm coming to Roman 2. The qualifying criteria parameters, example is there. It is a very wide thing now. Experience, financial resources, and the equipment fleet strength of the individual member of the JV consortium will be added together. So this gives an indication that regarding the local contents also, that will also come under the purview of this.
If local content comes under this purview of 2.2
Yes.
Roman 2, then it has to be added together.
Yes, we can add it. There's no difficulty on that.
Acha, but it can be submitted separate affidavit, that's what it is.
That is what they asked for and we have given. We have given both certificates. When they asked for a joint one, their
But
grievance,
your joint one was not a historical document.
it is not a historical document. No. Their only thing is that why the date is 17th and not prior to 5th. That is the ground. It is not regarding the composition
No,
or
that
the,
is not the issue.
that is
Or
not the issue with them.
That the issue is basically whether the local content affidavit can be submitted by, should be submitted by the joint venture as a whole,
As a whole.
or can it be submitted individually?
That
that
is
is the
not,
issue.
no, that is not the question, Lordship.
That has to be the question.
That question they have raised. But when we replied, they wanted a
I know
certificate.
their reply is different issue.
They are different things.
There
Yes,
is-
absolutely, Lordship is absolutely right from that perspective. That is the actual rational thinking. But what they have done, when they asked us that, give us a joint venture certificate on 16th, and they want a certificate backdated. So they want us to do some mischief.
Where is that historical document? That
Yes.
historical part?
200 next page on the
200.
that document we have submitted immediately. Yes. No. Page 201. This is the certificate.
No. Where it says that
Historical part.
yes, that
Clause
historical.
19.
Page.
Just 1 second. Document no, historical is here. Second page. 80. The short. It starts from clause, it is under clause 19. Page 79 it starts. Evaluation of tender. I would like to place 19 Roman 2B. once more, Lordship. That will clarify the whole situation. In case, because they will are doing the evaluation part, the tender committee. And the tender committee is constituted as per clause 19.1. After opening of tender technical bid, as the case may be, it will be evaluated by the constituted tender committee. Now coming to B. In case the tender committee finds that there is some deficiency in uploaded documents corresponding to the information furnished in bid submission confirmation sheet, or in case corresponding documents have not been uploaded by bidders, then the same will be specified online by evaluator, clearly indicating the omission shortcomings in the uploaded documents and allowing 7 days time for online resubmission by bidders. Additionally, information shall also be sent by system-generated email and SMS, but it will be the bidder's responsibility to check the updated status information on GEM portal regularly after opening of bid. No separate communication will be required in this regard. Non-receipt of email and SMS will not be accepted as a reason for non-submission of documents within the prescribed time. The bidders will upload the scanned copy of all those specified documents in support of the information declaration furnished by them in bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from bidders. Now that Lordship's query now. The shortfall information document should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not undergone change since then. This should be called only on basis of recommendation of the technical committee. So far as submission of documents is concerned with regard to the qualification criteria, after submission of the tender, only related shortfall documents should be asked for and considered. For example, if the bidder has submitted a work order document relating to a particular contract without its completion performance certificate, the certificate can be asked for and considered. However, no work order of new contract should be asked for so as to qualify the bidder. Now, taking the example, the second, if the second, this document is asked, that completion certificate. If they want that, I have done a work, they want a certificate, and I have not submitted that also. So I have to get a fresh certificate, not a backdated certificate. Now, what they have asked,
No, this is an additional document that they want.
more or less, it is an additional document.
It's an additional document because you have not submitted, so that person who has submitted his documents with regard to the contract might not have submitted the completion certificate. So they want the completion certificate so long as it existed at the time of the last date of
No,
submission of the
it has to
tender.
be completed.
Yes,
It
that
it
should
has
be.
to be completed,
Yes.
but that certificate, suppose I have not.
So
procured that.
it does not mean that does not mean that it has to be a pre-existing document. I mean,
Yes.
it does not mean that it has to be a document which has already been furnished. It can be a new document also, but which was there, which has been there, but
Yes.
not submitted.
It was not submitted. That is what we have done also. We have all the credentials regarding local suppliers content.
Your case seems slightly different. Your case seems to be that they want a document wherein all the three partners of the JV are mentioned instead of submitting separate local content affidavit. That is it. But where is it in the tender that these partners of the JV cannot submit individual local content
That they will have to show. They will have to show.
affidavit?
They will have to show. That requirement is not there. That is why there is a scope for addition of the credentials. If Lordship is pleased to come to page 60, Roman 2.
Huh?
Roman 2.
You can do
The qualifying,
what? Page 60,
page 60, Roman 2.
Roman 2 years.
The qualifying criteria parameters, that means 50% of local content. For example, they have given other examples. experience, financial resources, and requirement of street and strength of fleets of the individual members of the JV will be added together. That means when it is added, Lordship, when individual certificates, individual credentials are collected by them to the tender process, and they will have to do the adding part. If it is a composite one, then there is no scope for addition or subtraction. In our case, it is a case of addition plus divide. 100% the one, then the other person gave 50. So if it is to be joint venture, it has to be divided by 3. That also covers us. And therefore, they have not rejected our tender on that ground. What they have done, that our date, that is why I'll take this honorable court to that document. Why they have rejected, that also it's reflected in the yes, page 202. So our name is at serial number 3.
Yes,
So we are disqualified. There were 12 bidders. Only one bidder was they found to be qualified. All 11s are gone. Now page 205.
yes,
Reasons for technical evaluation history. Date is 22nd August 2024. Status disqualified. Other details indicated in the comments. Now comments. Number 1. The documents of local content submitted against the clarification is dated 17/8/2024, which is after the bid submission of end date is 5th August 2024. This is the last date of submission. So,
fifth of it, huh.
and the submitted document regarding consortium agreement is not in the line with the format provided in Annexure 2 of the ATC of bid document. Therefore, you are not fulfilling the required criteria as per requirement of the bid document. Our case is in a very narrow campus, Lordship. One is that date is 17th. When they asked us a document on 16th, definitely we cannot get a document of 15th or prior to that. So we have to give it, and there is no requirement within the tender, as Lordship has rightly indicated already. That where is the clause that burdens us that we have to give a certificate of the local content in the format of a JV and not in the format of an individual entity of the JV. That is not there. So they cannot, on their own whims and fancies, can frame a new clauses which is not there in the tender documents as well as in the additional terms and conditions for the bidding process.
What about the second portion?
Second now, Lordship. Mhm. Now, Lordship will kindly come to page 202.
Yes,
So here, Lordship will see this is the page which we can see in the on the screen. It's a screenshot. So as serial number 3, when we are considered as disqualified, then specification view and clarification view. When view we have to click, then the connecting page is flashed on the screen. That was not there when they sought the questions. 198.
with regard to that third
Yes,
request.
Lordship. They said that due to text limit by the GM portal, the query is attached.
Okay, so that,
There is
so,
no view here.
Okay.
We could not find out. They have simply in their affidavit said that it was there, but they could have at least annexed it in their affidavit.
so the second ground for disqualifying your technical bid
Yes,
is that content that you could not view.
no, that content, because what we have given, consortium, let us now come to our contract where they have found fault.
No, they have said at page 205, one is the 17/8/24. That too you, that too, I
That is
think,
one, that is
you have-
one ground.
that the other ground is, and the
that-
submitted document regarding consortium agreement is not in line with the format
Yes.
provided. What is this?
Yes,
That is request
what
number 3.
I'm placing now, Lordship. I'm.
No, is that amongst that request number 1, 2, 3?
According to them, it was request number that one.
Request number 3.
Yes,
That's what I'm saying.
yes,
So according to them is request number 3.
yes, Lordship.
So according to you, you don't know what it is.
We do not know.
So
But what we have done, because in the affidavit they have said, there are 3 queries. We knew 2 queries are in, what we have to, one is that
you have answered. Huh?
we have answered. If we do not respond to the third also, then it will, our first and second query also will not get uploaded in the system.
Is it?
Yes, that is the thing. So we have to, just for the sake of submitting these 2 documents, we annex another document in that, which is a working capital certificate, which has no relevancy with her at all. The India affidavit they have said. What exactly is there? Whether that query is relevant or not, that is the main query now, Lordship, main issue. Whether that will be substantial compliance or not. From that perspective also, we'll have to look into it. Now, what is our affidavit, our agreement, joint venture agreement, Lordship will? Is 107. Pro forma is 107. And what we have
For
submitted.
forma is 107. With
107.
regard to the request number 3.
Yes, yes, reference is 2 and 3, 2 and 5, where there is some deviation. What is that deviation? It is very flimsy, I should say. That deviation. Yes, it's Page 107 is their format, and what we have submitted, Lordship, that is joint venture consortium, page 45, annexure 1. It starts at page 44.
No, just a minute. This 205, they have said that the submitted document regarding consortium agreement is not in line with the format provided in Annexure 2
Yes,
of the ATC of bid document.
yes.
Where is this Annexure 2?
The format is 107 and our document is page 44.
Just a minute. 107, just let me see.
This is the format.
Now, page 1. So you did so is not in line.
This is not in line. Everything is there as per line, Lordship. Only 3 words we have inserted.
Page?
Page, it will start at page 44. It starts at page 44. There
Yes.
is no deviation. Lordship will kindly come to page, including page 46, lead partner. That Lordship will kindly take a note of. Here also there is no deviation, which is most critical and crucial clause. Page 47, joint and several liabilities. Here, may I read it, Lordship? Clause 7, joint and several liabilities. All partnership of consortium shall be liable jointly and severally to, as mentioned in the proportionate clause number 4, during the pre-qualification and bidding process, and in the event the contract is awarded during the execution of the contract in accordance with the contract terms. So what we have added here, page 47, as mentioned in proportionate clause number 4, that is the 4 letters words we have inserted. So I would like to read the photo there. So I have given the 2 separate sheet of paper, Lordship. So whether these 4 words, as mentioned, proportionate clause number 4, will make any substantial or material difference or deviation in the consortium agreement. Because lead partner clause 4 covers everything. In fact, these are two very frivolous grounds which they have taken to reject me and keeping me out of the race. Really acceptable. Lordship will kindly come to page 46. Clause number 4, lead partner. What I have given. JPW Infratech Private Limited shall be the lead partner of the consortium and is in charge of the performing the contract agreement. MS JWP Infratech Private Limited shall be attorney of the parties duly authorized to incur liabilities and receive instructions for and on behalf of any or all partners of the consortium. And also, all the partners of the consortium shall be jointly and severally liable during the bidding process and for execution of the contract as per contract terms and with the employer. This line is there. All the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per the contract terms and of the employer. So this covers everybody. What we have done, Lordship, in page 47. Share to
Page,
yes, at page 47, clause number 6. Participation share and work responsibilities. The party agreed that their respective participation share hereinafter called participation share in the consortium shall be as JWP Infratech Private Limited 50%, Joy Ambe Red Lines Private Limited 30%, Dev Mining Company 20%. Now, what we have said in 7, all partners of the consortium shall be liable jointly and severally to, as mentioned in proportionate clause in 4, that is above, that 50, 30, 20. During the pre-qualification and bidding process and
no, 4 does not talk about 50, 30, 20.
for lead
So
partner.
50, 30,
For lead
20.
partner also has the same thing.
Huh?
For lead partner has also said the same thing. The second part, all the partners of the consortium shall be jointly and severely liable.
Yeah, no, I'm saying, but the percentage is not given.
Sorry, I'm sorry. I stand corrected. So this is the case, Lordship. The facts are as simple as this.
Let's see how simple it is when the other side
Yes,
starts.
So one is that 17th August. That is the date which we have given. If we had given a 3rd August date with some manipulation, that is, they would have accepted it. What they are indirectly saying that you go and do some manipulation.
No, they're basically saying that we want a affidavit showing the consolidated local content
But
for all the 3 partners.
But
basically.
either say that date.
Huh?
But that again, we have to see whether that historical data was in existence at that point
No,
of
the issue is whether it is necessary. That is,
Lordship.
the issue is whether it is necessary.
That is
That
what,
is-
Lordship. In fact, both this,
Because you don't have it. You don't have that document. The issue is whether it's necessary or not.
it is not, yes, Lordship. From that perspective, yes, It is not necessary, it is not prescribed under the.
Because if it is necessary, then you lose out.
Then I am out of case.
So then your case has to
Then
be,
Lordship, I would not
your
have come
case has
before.
to be that it is not necessary.
That is why, Lordship, if we had failed to fulfill any of the eligibility criteria, then I have no case at all.
Mm.
But here I have everything.
Anything else? I think that's
Lordship,
enough.
Lordship will hear the other side, and all the judgments he required, I will place, Lordship.
Where's the judgment? So if necessary, we can.
Then
Ah, because
let the facts be clear, Lordship.
He doesn't,
The story
He
has to be seen.
he
from that
doesn't want to show all his cards at the moment.
I have a right to
Ah.
reply, Lordship. So in the reply, I have the judgments ready, Lordship. It is not that I have a compilation also. Because the facts,
In that case, that should be very clear, that we'll have a further right to reply.
That is there again.
why I am saying, Lordship, if the facts from the other side becomes more clear, the judgments will be more appropriate.
Anyway, let's see. Yes. Mr. Amit. What is your case? Your father,
Right, notice and court fees.
for the respondent number?
Right.
5. So his case is basically twofold. One is that the local content affidavit submitted individually on individual basis has substantially complied with the requirements of the NIT. In as much as there is no clause requiring the local content affidavit to be made in the name of all the partners of the JV. That is one.
And
What reply do you have to that?
that your lordship, I'll take your lordship state to page 73.
Page 73.
Last 3.3 notes.
3.3 notes.
Page 73.
Last.
3.3. Yes.
The documents to be furnished by the bidder
It's
to prove that he is satisfying.
No. Okay. The notes. Yes.
The documents to be furnished by the bidder to prove that he is satisfying the eligibility criteria laid down should all be in the bidder's name.
Yes.
Bidder is the joint venture consortium. All the three partners.
No, but somewhere it was said, that,
This is the bid submission contractor sheet. And this is the consortium. Consortium means, so we can get a bidder. That's the requirement. First of all, that's. And election fund will come and affect the main projects. Basically, the criteria, page 62 to start with, page 62.
okay.
Page. It is 62 to the over, page 62. This one is for functions. That is just, yes, it's required. Page 62.
Your lordship will come to page 62.
Eligibility criteria. Requirements.
Yes.
Which indicates that what is the eligibility criteria of the bidder.
Yes.
First,
Eligibility 3.1A. The eligibility criteria to qualify for award of the contract. A is the bid submission confirmation, BAC sheet. Bidders are required to submit the duly filled bid submission confirmation sheet in PDF format as per instructions provided in the GEM bid document and the session bid. Confirmation sheet for technical evaluation. The bid submission confirmation sheet provided by buyer in secure XLS format. The scanned copy of the documents will be verified against the data furnished in the bid submission confirmation sheet. If this is a basic document.
it is, bid submission is an Excel one. Right?
Here the DNI.
Of the petition. Affidavit.
And the Lord will now see our affidavit, page
Yes,
472,
Affidavit respondent number five.
annexure 1.
Affidavit respondent number 5.
Yes,
You got it? 472. You will see
This is the bid submission confirmation.
bid submission confirmation sheet.
Huh?
Bid submission confirmation sheet.
Of the petition.
This is of the petitioner.
yes,
This is to be submitted by all the bidders.
correct.
And here you also will see bidder's legal status, proprietor partnership limited company, JV consortium. They stated consortium. The bidder is a consortium
Correct.
and
Not in the name of
not in the name of the
individuals.
individual partners.
Applicant will require to name the bidder.
On 7.0 in the column. Confirmation of yes, no regarding possession of requisite document of legal status of bidder as per requirement of bid documents. What they have stated is that
Yes.
it is a yes. But what they have submitted along with the bid submission confirmation is data which was not satisfactory according to us.
Hmm?
It
Yes.
was not satisfactory.
Is 95. Yes. Scanned. Yes.
You will see page 95 of the writ petition. What is required to be submitted?
Page 95.
95. What is required to be submitted by the tenderer in the bid submission confirmation sheet is that bidders are required to, number one, bidders are required to submit the duly filled bid submission confirmation sheet in PDF format under section bid confirmation sheet for technical evaluation. The bid submission confirmation sheet provided by buyer in secured XLS format. The scanned copy of documents will be verified against the data furnished in the bid submission confirmation sheet. Any bid not accompanied by a bid submission confirmation sheet, or if BSc is found tampered, that the GTE and work experience, working capital, etc., the bid shall be considered as non-responsive and is liable for rejection.
If not obtained, page 90.
Then you know she will come to page 98 to clause number 10. Legal status of bidder. Confirmation in the form of yes, no for possessing the supporting documents. The comments are there. Any one of the following documents, affidavit or any other document to prove proprietorship individual status of the bidder. After clause 4, the following documents in respect of legal status of a JV consortium bidder shall be uploaded by the JV consortium bidder. Scanned copy of JV consortium agreement containing name of partners and lead partner, power of attorney of the lead partner, and share of each partner. Through board resolution, power of attorney as applicable. That is not necessary now. The documents, any of them as applicable, at page 99, regarding legal status of all the individual partners of JV mentioned below, a affidavit or any other document to prove proprietorship, individual status of the bidder, or partnership deed containing name of partners, or memorandum and article of association with certificate of incorporation containing name of bidder. It is only bidder. It is not three partners separately. The joint venture must produce documents in the name of the joint venture.
No, it is, but then this page 98 is with regard to these documents only. It does not talk about local content.
I'll come to local content. Whatever clarification is given regarding any of the documents, those documents must be in the name of the bidder, the consortium, not by individual.
But supposing they have become partners for the consortium or for the joint venture only for this work, where will they have a past joint document with regard to the local content?
The agreement along with the authority given to the lead partner.
Huh?
The agreement along with the name of the lead partner, all should be clarified.
Yes.
The bidder has accepted all the conditions of the tender.
Correct?
They agreed to abide by it, and here they need to serve. The local content will be required.
Tree. Yeah, it's a requirement. At page 73. It is a requirement. This one. Page 73. Paragraph number 1. 67. Page 73. Paragraph number 17.
Now, if you come to page 73,
Paragraph number 7 from top.
Yes.
paragraph 7 from top.
73, there is no paragraph 7.
No, I'm from top and 7.
From tops.
Oh, from top, page 73 on top. Yes.
Paragraph number 7.
Paragraph 7.
1, 2, 3, 4, 5, 6.
If the estimated value of procurement is more than rupees 10 crores, all the bidders shall submit along with his bid a certificate with issued in NSN 9.
Where are you reading?
It is
Which para? Which
No.
page?
page 73,
Which on top, bottom, where?
the middle of the page.
Middle of the, in respect of
Paragraph number 7.
7?
No, paragraph 7, it is.
There is no paragraph 7 in page 73.
No, no,
Serial number.
middle of
There
the
is no
page,
serial number
come
7.
to clause B, small b. Small b.
73. 173 or
No,
73?
73, clause B.
Clause B.
Yes.
It speaks of class 2 local supplier.
No.
Hereafter.
Below, non-local supplier.
If-
Local content.
No.
Margin of purchase preference.
Is that page 73?
It is my page says it is 73. I don't know whether your page 73 and my page 73 are the same.
No, no. Number 28.
RB.
It is part of paragraph 3, 1,
RB, 31 RB.
31R is at page 72.
Yes, 31 RB. It will come with 31 RB.
31RB. That is class 2 local supplier.
in that line,
Midst of page 73, in the midst of page 73.
Yes. Give the estimated value.
Yes,
Yes.
yes.
Okay.
if the estimated value of procurement
Is up to 10 crores.
10 crores,
Ah, 10 crores. Okay.
all the bidders shall submit along with his bid a certificate with Udin Annexure 9A from the statutory auditor or cost auditor of the company in case of companies or from the practicing
Okay,
cost
all the
accountant,
bidders.
giving the percentage of local content. It has to be the bidder, not again the individual, which they have not done.
They have said in this they have, yes.
Hmm? Matriculation. What they've stated at page 472 of our affidavit in that bid submission document, confirmation sheet, was yes. But in spite of saying yes, they have not given veto in the data. The documents are not in the name of the bidder, it is the name of individuals.
Annexure, this talks about annexure 9. 73, this A
Yes.
talks about annexure 9. Where is this annexure 9?
And yet,
Next one. Page 120. Page 128. That's shown.
This is annexure 9A. There's a
9A.
difference. Annexure 9 and annexure 9 is different.
No, this is 9A.
9A is
In the paragraph, it is
128 talks of annexure 9A.
9A. This is
Page 73A talks about annexure 9. There is
9A.
no A.
no,
There
B,
is.
B.
Huh?
9A is the.
9 is the B. Is B.
B.
It is not A, it is B.
ठीक है सर B then A to B is that B is more than 10 crores therefore 2000 crores right more than 10 crores
9A, it's more than 10 crores. This contract is over 2,000 crores.
Okay, so it'll come to 10, so 27 B.
Yes.
yes
The format is clear.
that is the specific one
Certificate of local content as per public procurement. Reference to Make in India order 2017 as amended from time to time. And here it is clear that the bidder has not been named. There's no certificate in the name of the bidder. And they've sought to mislead us by saying, yes, they will do them. Lordship will see clause 3.3. The notes which I only placed
Page 73.
is
Notes.
I'm repeating this. Notes, the documents to be furnished by the bidder to prove that he is satisfying the eligibility criteria laid down should all be in the bidder's name. That means a joint venture. But
The clarification on. It's very, very, very,
99.
198. We've given him the sums, but they fail. It's 198. But they fail.
Here, we had given them the opportunity to clarify. Those three clarifications of sorts. One is already regarding the typographical or unclear affidavit they had given. That is no problem, but as far as
She can do project.
Mhm.
It will be. They couldn't do it. Public is also, because here is from the government is also.
very completely.
One or against it.
Only your worship. My learned friend had said that they had defeated by using only 4 different words, which your worship had seen. But that is wrong.
Show me how it is wrong.
I'll just please, your worship will have to see both the documents together. Which one was it?
I mean, what we are required.
He required me.
What we are requiring at page 109. What we are requiring at page 109.
You have to-
Page 47.
Your lordship has 2 copies. Put a copy as well. Three. Our requirement is at page 109.
109.
Starts from 10. Starts from 107. Starts from 107.
Yes.
Starts from 107.
Can we, do you think we can, at the pace we are going, will take a long time? Do you think we can take it up at 2 or something? I'll finish off some of the cases. Because there are a lot of other cases pending. I don't know.
Yes, lordship,
I do not know,
on the-
depending
on
on.
Tuesday, lordship will complete it. So I have also 3 other part heard matters. I have kept all those cases pending. This is item number 1, so I have.
How long will you take, Mr. Raman?
Take a little time because my learned friends will also have to.
No, that is all right. I'm asking you.
Fine, within an hour I can say.
Huh?
Within 1 hour,
Within 1 hour. Within 1 hour.
or less.
Okay, then we can take it up at 2. If it's all right, I do not know. Because at least I can finish the other cases in the meantime. Because we have been doing this only since morning. I mean, there's hardly anything to say. One is your case is that the bidders, the documents that have to be submitted has to be in the bidder's name. And the documents that are submitted by them was not in the bidder's name, it was in the individual partnership names, partnership members' names. So that is one. The second point is with regard to request number 3, they said that they did not receive a copy of they did not receive the attachment with request number 3, but nevertheless, they submitted what they thought was asked for, and the only difference is that there's an extra 5 words there, which is not there in the affidavit as per affidavit number 9, the performer. So whether the addition of those 5 words, 4 or 5 words, changes the subject matter at all, does it? It does.
It's more than 4 words, I'll place it.
Huh?
It's more than 4 words, I can place it.
Okay, it's more than 4 words. How many words?
Paragraph.
Paragraph. And does it materially change or deviate the
Yes.
contents of the affidavit?
Yes, it does.
Okay.
That we were asked, but they did not provide.
So then you just show me that. That's all. What is there to say beyond that? There's nothing much. You show me that.
Okay, half an hour, I'll place that.
Okay, within half an hour you'll finish. Okay.
Along with the, let's be at 2 o'clock, that is.
No, we can do it before lunch. We'll finish everything before lunch. Is it okay? We'll finish everything before lunch. I hope so.
This way, it did not-
Because there's nothing much beyond that.
Your lordship will see the performer,
128,
that,
No.
no, 107,
107.
at
Yes, 107. Annexure 2.
Annexure 2,
Yes.
at page 109.
Page 109. Yes.
What they were nine, Clause 5. All,
5. Yes.
all partners of the joint venture consortium shall be liable jointly and severally during pre-qualification and bidding process. And in the event the contract is awarded during the execution of the contract in accordance with contract terms. During the execution of work service, the requirement of working capital shall be met individually or collectively by the joint venture consortium partners. This is not that important, but
So you have to compare this with page 44.
what you.
Yes.
Vote. 47 is the format submitted by the petitioner.
Yes. Page 47 is the relevant page.
Yes.
It starts from page 44. So 47 at clause 7. It speaks of as mentioned proportionate clause number 4.
And what is clause number 4? Because people see. It's something totally irrelevant. Does not match. It mentioned about lead partners. The PW Infotech Private Limited shall be the lead partner of the consortium and is in charge of performing the contract management. Message, JPW Infotech Private Limited shall be attorney of the parties duly authorized to incur liabilities and receive instructions for and on behalf of any or all partners in the consortium. And also all the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per contract terms with the.
So it's the same thing.
No.
Where is the prejudice caused to anybody?
They did not produce this. We asked for this.
Actually, they did not produce
They
this.
did not.
But you did not produce this.
Produce.
You produced it.
We produce.
If you did not produce, you could not have uploaded the other two
Yes, yes.
requests, 1 and 2, correct?
They did not upload at the time of query. I mean, at the time of query, I did not, they produced me the working.
That 4 additional words or 5 additional words we have inserted as per clause 4.
Actually, if,
No, when you made the query, they did not answer.
that part, so now you see, the petitioner's counsel is saying that that was answered because unless we answered that request number 3, request number 1 and 2 cannot be uploaded.
No, that has come down in the writ petition. It was not raised earlier. We stated in our
I
affidavit.
don't know, these are,
No, there's
that
something,
is a question of fact, I don't know.
it just come newly.
So you mean to say this page 47 was not uploaded by them, is it?
Earlier,
It was uploaded earlier.
then we have short whether this is same or not. They did not answer us that it is same.
We sought for a query as to whether this document annexure
One,
one,
For a moment, your lordship can come to page 491 of our executive. But starting with the
If I may interrupt for a moment. If records are called for lordship, because that affidavit, we made it on 2nd of August and we uploaded. If the records are called for, everything will become clear.
anything to say? Are you here in this case?
And for the option of the.
Okay,
The main.
okay, then, okay, so you are the one who can throw light with regard to whether,
Very, very limited.
uh, complete. Depending upon Mr. Zaman, we have to leave it up to him what,
page 491,
how long he'll take.
page 14.
I mean, Mr. Ahmed. Yes, Mr. Ahmed, so your case is that it was not uploaded.
no doubt. We've done it earlier, but when we asked query it about it, whether it was.
Now we are going back to square one. We are going back to facts now.
Page 491.
So the question we,
Listen about this in page 491 of our affidavit.
491 of our affidavit.
491 you have mentioned. Page 491, let me see.
Minus of the tender copy.
491,
Minus of the tender copy.
491. Scheduled for 2 hours.
This is part of the
Minus of the tender.
491, yes, 491, yes.
minutes of the tender committee
Dated 14/8.
dated 14/8.
And it starts from 476.
Yes, so
Starts from 476,
which page now? 491?
491.
Yes,
Technical clarification shortfall document
yes.
to be sought from one bidder, namely the petitioner.
It is
Bidder to submit the certificate in the name of the joint venture issued by practicing
Yes.
cost accountant or practicing chartered accountant regarding local content as per annexure 9A of the additional terms of condition of the bid document. Bidder to submit a clearly readable copy of partnership deed of Messrs. Dave Mining Company. Bidder has serial number 4 of consortium agreement stated that all the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per contract terms with the employer. And at serial number 4.3 of 6, that is participation share and work responsibility, stated that, however, all parties shall remain jointly and severally responsible for the satisfactory execution of the project in accordance with the contract terms and by the serial number 7, joint and several liabilities, stated that all partners of consortium shall be liable jointly and severally to the as mentioned proportionate clause 4 during the pre-qualification and bidding process. I'm sorry, I'm not in a position to continue. I just came out from the hospital.
Oh, so what do you want? Oh, yes, so make him sit. Mr. Ahmed, you can sit then. Yes, Mr. I one query,
What I'll do
just
is-
one query,
My lord.
before you start off. Whether the local content affidavit or that has to be submitted, undertaking. Whether it should be done in terms of the bidder's name, or it can be done
It has to be in the
individually.
name of the bidder. The logic, I'll do is, I will make my submissions in 4 different parts. Firstly, what is the requirement under the NIT? What is it that they submitted? How we evaluate it? And what is the law? These are the 4 areas that basically sums up the case. Now, let us come to first, let us understand why. What is the concept of a joint venture? Only because they do not have the eligibility individually. They come together and form a consortium or a joint venture.
Maybe,
Therefore, we need
maybe they have, how do you know that they
No.
don't have? They might have.
The
the
idea
capability.
is, the coming together normally happens only because one cannot fulfill the criteria on his own. Or assuming
How to
otherwise,
make a stronger entity.
make a stronger entity, perhaps. So when someone participates as a joint venture, what is it that the tendering authority needs to do? Whether as a consolidated group, they would be able to perform the contract. But that is what we are required to test. Now let us understand the terms of the NIT. Your Lordship will straight away come to the NIT, which starts at page 51. Your Lordship will find that it has been invited at page 51. The NIT tenders have been invited by Coal India.
Page 51.
And page 52 itself, this is one most important provision in the NIT, which has not been placed. Who can participate? Clause 1 at page 52. Tenders are invited online on website so-and-so from the eligible bidders. The registration should be in the name of the bidder for individual, proprietorship firm, partnership firm, company registered under the Companies Act. Whereas for participation of joint venture consortium through GEM portal, the registration of bidders should be in the name of the lead member of the joint venture consortium. And this is the most important part. And the submitted document against eligibility criteria should be in the name of joint venture consortium. So all eligibility documents, it is the joint venture, because we are testing whether you as a joint venture can perform the contract or not. Now, your lordship will kindly come to page 60.
Yes,
This is additional terms and conditions. Eligible bidders. The invitation, 2.1. The invitation for bid is open to all bidders, including an individual proprietorship firm, partnership firm, company registered under the Companies Act, or a joint venture consortium. The bidders shall be eligible to participate only if they fulfill the eligibility criteria specified in bid document, additional terms and conditions. In a tender, a bidder shall participate in one bid only. So if we read page 52 with 60, it is the joint venture who is the bidder, and it is that bidder's qualification that we are examining. Now, next 2.2 is very important. Each entity will be jointly and severally responsible for completing the task as per the contract. Next, subclause 2, the qualifying criteria, parameter, example, experience, financial resources, and equipment fleet strength of the individual member of the joint venture will be added together. What will be added together? Experience, financial resources, and equipment fleets, etc., can be added together. And the total criteria should not be less than as spelled out in so and so. So the reason is very simple. Financially, each of the bidders individually may not qualify, but we will add up. When you are participating as a joint venture, your financial criteria will add up. Or
does the local content come here?
how can it? Because the local content itself is how much of, once I place the relevant portion of the format, it will be very clear. But before that, let me, while I am on page 60, let me place the other.
So local content does not come within this 2.2.3.
Certainly cannot, because this is experience, financial resources, etc., are completely different. Those are in a different realm altogether. Now, your lordship will kindly come to subclause 4. This is also very important.
Yes.
The bid, and in case of successful bid, the agreement shall be, the bid also has to be, not only in case of successful, the bid, and in case of successful bid, the agreement shall be signed so as to legally bind all members jointly and severally, and any bid shall be submitted with a copy of the joint venture consortium agreement, providing the joint and several liabilities with respect to the contract. Now, if your lordship kindly turns the page to page 61, clause 6. The
Yes.
bid submission must include documentary evidence to the relationship between joint venture consortium members in the form of JV consortium agreement to legally bind all partners jointly and severally for the proposed agreement, which should set out the principle for etc., constitution, etc., etc. Now, if your lordship kindly turns to page 62, eligibility criteria of the bidder. Your lordship will kindly mark the word bidder. So this eligibility criteria will be qua bidder. It might be if he participates as an individual, it will be his individual eligibility. If it is a joint venture, he is participating as a joint venture, so therefore the joint venture. Now, this is very important. Subclause A, bid submission confirmation sheet. So, along with the bid, they are required to submit this. Bid submission confirmation sheet. Bidders are required to submit the duly filled bid submission confirmation sheet in PDF format as per instruction provided in the GEM bid document under section bid confirmation sheet for technical evaluation. The bid submission confirmation sheet provided by buyer in secured so and so format. The scanned copy of documents will be verified against the data furnished in the bid submission confirmation sheet. So the scanned copies of the documents that are being uploaded with the bid will be cross-checked with the bid submission confirmation sheet. This is more like an index. So now
What is the relevance of that?
relevance
Of this?
is that I will come when I come to the evaluation part, how the tenders are to be evaluated, which is provided in the NIT itself. At the very first instance, the technical committee, the tender committee is required to, the first step in the evaluation process is that we will check, verify the documents and cross-check it with the bids, this confirmation sheet. And if it is not found in conformity, he is liable to be rejected. Now, coming to this Make in India controversy, Madam, if your lordship will kindly come to page 72.
Yes, sir. Yes. Page
Pa-
72.
Page 72, subclause R in that page, towards the bottom.
Yes.
Because now your lordship is aware, the government is putting a lot of trust on this Make in India. And therefore this clause. Documents as required to comply with order number so and so for preference to Make in India as applicable issued by Government of India as amended from time to time shall be submitted. In terms of the above said policy, purchase preference shall be given to class 1 local supplier. Now, subclause A thereof, class 1 local supplier means a supplier or service provider whose goods, services, or works offered for procurement has local content equal to or more than 50% as defined under the said order. Now, one may procure, just to hypothetically give an example. Let us assume one auto manufacturing company is procuring some parts from abroad, maybe Japan, Korea, somewhere. There has to be a value addition to that, to the extent of a minimum of 50% in India, within the country. Now, if your lordship will kindly turn the page, what is local content is also defined as subclause 2, page 73.
Yes.
Local content means the amount of value added in India, which shall be the total value of the item procured, excluding net domestic indirect taxes, minus the value of imported content in the item, including all customs duties as a proportion of the total value in person. Now, just after E, your lordship will find a heading. How does one establish that he meets this criteria is this? In respect of the above eligibility criteria, your lordship will mark this word. The bidder is required to furnish the following information in bid submission confirmation sheet. So it is not like individually you come up 100%, 150%, 200%, does not matter. You might have 1000%. We are not concerned. What we are concerned with as a bidder, you have bid as a joint venture. As a joint venture, whether you fulfill the criteria or not. Now, we are not concerned with subclause A there because this is for contracts less than 10 crores. This is a contract of more than 1,000 crores. So we will fall under B. If the estimated value of procurement is more than 10 crores, all the bidders shall submit along with its bid certificate with UDIN, Annexure 9 capital A, from the statutory auditor or cost auditor of the company in case of companies, or from a practicing cost accountant or practicing chartered accountant. Your lordship will kindly mark this one. In respect of suppliers other than companies. So he will fall within this, since he is a joint venture and is not a company. Giving the percentage of local content. Now, notes my respected senior friend had pointed it out. The documents to be furnished, it is further clarified, my lord. Documents to be furnished by the bidder
to prove that he is satisfying the eligibility criteria laid down should all be in the bidder's name. So there is no scope for any confusion here. Now, what is this format? Let us understand this format, which your lordship will find at page 128. We are in that page. We are not concerned with the second part after or. We are concerned with the first part. IV, the statutory auditor, the cost auditor, practicing cost accountant, practicing chartered accountant, within brackets, strike off, which is not applicable, of Messrs. So-and-so having registered office at so-and-so hereby confirm that the percentage of local content in the offered product service of Messrs. So-and-so is so-and-so percent. They have to fill this up and meets the local content requirement for class 1 local supplier as prescribed under public procurement preference to make in India order 2017. Now, if your lordship comes down, this is the important part. The details of locations at which local value addition is made is or are as under. So merely saying, because anyone might produce any certificate saying that so-and-so is 75%, so-and-so is 80%. What is the extent of the value you have added to the products? That is required to be specified. So that is how, if necessary, we can cross-check. If they say that I am producing Hyundai cars, so how much of it is imported and how much of it is actually value is added in India? If these facts and figures are given, we can always cross-check. Now, if your lordship will now come to page 76. This is very, very important. How will the bidders sign and submit the bid? Page 76, clause 15. And subclause C thereof. The bidders will have to accept unconditionally the additional terms and conditions, instruction to bidder, service level agreement, etc., integrity pact and other conditions, if any, along with undertaking in support of the authenticity of the declarations regarding the facts, figures, information, and documents furnished by the bidder through BSC. This is BSC is again bid confirmation sheet. And online in order to become an eligible bidder. No conditional bid shall be allowed accepted. Your lordship will kindly mark this. Now, what will they upload? Subclause I. For online submission of tenders, the bidders will have to upload the following. For two-part system, all confirmatory documents as prescribed in the bid document in cover 1, etc. Next, subclause 3. Confirmatory documents, technical clarifications. All the confirmatory documents, technical clarification as enlisted in the bid document in support of online so-and-so through bid submission confirmation sheet by the bidder are to be uploaded in cover 1. Now, page 80.
No, but so this 77, how does this confirmatory documents technical clarification? So this includes local content according to you or what?
Yes, because technical bid is part of the local content is part of the technical bid. Only when all these criteria are fulfilled, only then the financial bids will be open. These are all part of the technical bid. Now, how will the evaluation take place is at page 79. How will the evaluation take place and by whom? By whom is also very relevant. 19.1.
Yes.
After opening of tender technical bid, as the case may be, your lordship will kindly mark this one. It will be evaluated by the constituted tender committee. And that tender committee is not even a party before your lord. For two-part system. I'm not even saying that any malafide has been alleged. They have not even been made a party. So it is the recommendation of the tender committee based on which we have taken our action.
Is it required?
I'll come to
Tender committee is just a recommending body.
Yes, but the entire onus is trust in the under this tender document. The onus is trust on the tender committee to do the undertake the decision making process.
No,
How it has been done also that will clarify your lordship's query.
if the challenge is made to the decision, that's enough, I think.
But that I think Onkar Lal Bajaj says if the parent action itself is not put to question.
This is more like,
No, that will be, my lord, clear once I come to the decision-making process, which we have annexed to the affidavits. All the records that my learned friend Mr. Saikia was suggesting, all those records we have annexed to the affidavit. I'll place all those. But before that, my lord, how the evaluation is to be done is that just after that, what I read out, for two-part system, what is the first step? After opening of technical bid, the documents submitted by the bidder in cover 1 as enlisted in the bid document will be downloaded by the evaluator and shall be put up to the tender committee. The tender committee will examine the uploaded documents against information declarations furnished by the bidders in bid submission confirmation sheet. The lord will kindly note this. The very first stage of the tender evaluation is they are required to cross-check with their own document in the form of bid submission confirmation sheet. If it conforms to all the information declarations furnished by the bidder in bid submission confirmation sheet and does not change the eligibility status of the bidder, then the bidder will be considered eligible for opening of price bid. Your lordship will kindly also note this. If it does not change the eligibility status of the bidder. Now, next. In case the tender committee, this was read out by my learned friend, Mr. Saikia, but I would still like to, for the sake of pointing out some relevant portions. B, this is very vital. In case the tender committee finds that there is some deficiency in the uploaded documents corresponding to the information furnished in bid submission confirmation sheet, or in case corresponding document have not been uploaded by bidders, then the same will be specified online by evaluator, clearly indicating the omissions, shortcomings in the uploaded documents. Your lordship will kindly mark this one. And allowing 7 days time for online resubmission by bidders. So only if there is any deficiency in the uploaded document, that will be called for. And therefore, it is further clarified in the next page that historical documents only will be accepted, which were pre-existing on the date or last date of submission. Now, reading further, my lord. Additionally, information shall also be sent by system-generated email and SMS, but it will be the bidder's responsibility to check the updated status information on GM portal regularly after opening of bid. No separate communication will be required in this regard. Non-receipt of email and SMS will not be accepted as a reason of non-submission of documents within the prescribed time. The bidders will upload the scanned copy of all those specified documents in support of the information declarations furnished by them in bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from the bidder. Now, next portion is next part is very important. The shortfall information document should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not undergone change since then. To the word only and this next phrase, which have not undergone change since then. That you cannot be permitted to submit any fresh document. It is only the document that you have uploaded. If there is any clarification, you can clarify, but no fresh documents. So far as the submission of documents is concerned, with regard to qualification criteria after submission of the tender, only related shortfall documents should be asked for and considered, and an example is also given. it is next C. It is the responsibility of bidders to upload legible, clearly readable scanned copy of all required documents in the bid document. Now, next, E, in case the bidder submits requisite documents online as per bid document, then the bidders will be considered eligible for opening of price bid. Next, F is very important. Seeking technical clarification shall be restricted to confirmation of submitted documents only. And it should be only for one time for a period of up to 7 days. The clarification shall be taken in online mode in the e-procurement so-and-so. Then H is very important. In case the bidder fails to confirm the submitted information declarations by the submitted documents as B above, his bid shall be rejected. So it is not that some discretion is given. It has to be rejected. And next shows that only the price bids of those who have passed through that first hurdle, only their bids will be open. Now, coming to this is so far as the requirements in the NIT are concerned. Now, let us see what he had submitted. Your Lordship will first come to the consortium agreement at page 44. It starts at page 44. And the controversy that got created is because of this. Clause 7. Joint and several liabilities. Your Lordship has seen several conditions in the NIT which says that you will be jointly and severally liable, and you have to make that position clear. Now, what the problem, how it arose? All partner of consortium shall be liable jointly and severally to the as mentioned proportionate clause number 4 during the pre-qualification and bidding process. Your Lordship has seen this. As mentioned proportionate clause number 4. What happens as was done? We tend to move back to page 46. It is not the page 46. Your Lordship will come to page 47 again. Although the main clause is marked as 6, the sub clause is 4.1. Has your Lordship seen that? And here they are mentioning proportionate shares. This becomes a conditional bid. We said that you clarify this is not as per the format. Your Lordship will kindly come to the format now. The format is at page 107. Even the serial numbers have been changed. Your Lordship will see that joint and several liability is at page 109. Your Lordship will see the serial number. Serial number is 5. And your Lordship will come back to page 47. Their serial number is 7. And now they are making it as mentioned proportionate clause so-and-so. So this becomes a conditional bid. And in your own clause, although there is another clause 4, but clause 6 has a 4.1. How do we know that you are not fooling around with us? How do we know that you are making a mockery of this tender process? That is why we ask for this clarification, that what is this business? You are offering a conditional bid. So if we read this 4.1 with 7 together, what happens is each partner remains liable for 50%, 30%, 20%. We are unable to distinguish which 50%, which 30%, which 20%. How can we give out a contract, hand out a contract to such a party? What risk once we sign the contract, the next day itself, if he says that we won't do it, but pay us the money, what guarantee do we have? So now your Lordship will kindly come to the second problem. Make in India certificate. What is it that they submitted? Your Lordship will find page 200 is the first, one of the partners.
Page 200.
Page 200. And your Lordship will simultaneously have that format also. At page 73.
page 200 is
one of the partners. Huh? 120. Your lordship will simultaneously have page 128
page 128 with page 200.
with page 200, because 128 is the pro forma of the format which is given with the bid documents. This is what they are required to submit. And what they submit is this. Page 200 and 201. Yes. One says, in respect of one of the partners, one says 50%. But how much is the value addition? There's no mention. Where is what value have you added? How much? Have you imported the whole 100% here and just put a seal that I have made in India? We don't know. Then page 201, same thing. And on top of it, it is not in the name of the bidder. And the third bidder, if their understanding is that individually it has to give, where is the third bidder? So therefore, we
Wait, page 200,
and 200,
201.
now your lordship will kindly also mark the dates in these two documents.
Yes.
2nd of August 2024. And the other one is 12th July 2020. And your lordship will also make a note of the last date of bid submission. That is 5th of August 2020.
Feb 7. 20. And last date is 5th.
5th of August, because we are required to, we can take only historical documents which pre-existed. Now, these are the documents that were submitted. He had another problem. He had submitted an illegible document, which we asked for it. He subsequently furnished a legible copy of that. We accepted that. Now, let us come to the decision-making process. How the decision-making process took place. Your lordship will take up the affidavit in opposition by the respondent number 5.
Page.
It should start at page 433. The
Yes.
tender committee held its first meeting on, your lordship may just make a note of this date, 14/8/2024. And that
First meeting on
14/8/2024. And the minutes thereof are annexed at page 476. Your lordship will kindly turn to page 476. And your lordship will find that it is not like things happen in many of the state governments, not a one-page minutes. It's a thorough minutes. They examined, they went into the details of each and every tender. If your lordship will kindly turn to page 479, this document, my lord, runs into almost 30 pages, 20-30 pages. Now, if your lordship will kindly come to 479, your lordship will find at the very top that 12 tenderers had participated. And one by one, each of the chart represents each of the tenderers. Your lordship will find that the first, Almighty, and your lordship will kindly note the observation of tender committee. The bidder is non-responsive and liable for rejection. Further evaluation of bid shall not be carried out. Summarily rejected. Next one, summarily rejected. The third one is the petitioner. And your lordship will see the evaluation. The extent of the details. Your lordship will just have a look at the headings, description, documents submitted by bidder, and observation of TC. Your lordship may skip over various aspects were evaluated, and in respect of each, your lordship, just to take an example, in respect of the first document,
Let's go to the main.
yes, main is 482. The second stage of evaluation will come later. We are now at the stage of confirming with the bid confirmation sheet. 482, your lordship will find the second row, public procurement preference to make in India for local supplier. Now, what has he submitted? Bidder submitted the following documents: a certificate dated so and so 2824 issued by CA Arvind so of so and so, and the second certificate is also mentioned. And now, what is the observation? Bidder not submitted a certificate in name of JR so and so issued by practicing cost accountant or practicing chartered accountant regarding local content as per Annexure 9A of ATC of bidder. So, where is the fault in the decision making process? Now, next one, legal status of bidder. First is bidder not submitted a clearly readable copy. So we asked, I'll show that. We asked for one, he gave a clearly readable copy. So I'm not troubling your lordship with that. Your lordship will kindly turn to page 483.
Yes.
Towards in the right hand column, line about 10 from bottom,
Yes.
but at serial number 7. Your lordship will kindly note that.
Last column.
Last column, towards the bottom, line about 9 or 10 lines from bottom. There's a line
Yes,
starting but at serial number
Yes.
7.
Yes.
But at serial number 7, that is joint venture and several liabilities, stated that all partner of consortium shall be liable jointly and severally to the as mentioned proportionate to clause 4 during the pre-qualification and bidding process, and in the event the contract is so and so. So that is reproduced. Now thereafter, they could have rejected him at that stage itself because it was not in conformity. We wanted to be fair. Towards the bottom, your lordship will find, on the evaluation of the documents submitted online, TC observed that bidder so and so to submit the following clarification shortfall documents. And in the next page, what are the documents that we wanted? Bidder to submit the certificate in the name of so and so issued by practicing cost accountant or practicing chartered accountant regarding local content as per Annexure 9A of ATC of bid document. So if you actually have that document prior to the date, please furnish, because we cannot accept subsequent documents. What he did was he submitted a document dated 17. How can we accept? Because the tender condition strictly prohibits accepting any later document which changes the eligibility of the bidder.
No, he doesn't have it. That's why.
If he doesn't have it, as it is, he is not eligible, because the language employed in the tender is very clear. It is the bidder who has to submit. We could have ousted him at that stage itself. I am just pointing out now, second is bidder to submit clearly readable copy of partnership deed so and so, which he did. We later on condoned. I'll point out from the next minutes. And the next one, we asked for a clarification that as mentioned proportionate share, that has to be towards the bottom of that, my lord, line about 5 from bottom.
Yes.
A clarification is required whether the statement written at serial number 7 for liable jointly and severally is in line of the statement at serial number 4 and serial number 4.3 of 6 of consortium agreement submitted by bidder or liable for proportionate share, etc., etc. That is the clarification that we wanted. Now, once you submitted the documents, again the tender committee met, and that minutes your lordship will find, because 7 days time is required to be allowed. We allowed that 7 days time. He uploaded some further documents, and based on that, the next round of evaluation took place on 22/8/2024. which your lordship will find at page 492.
Yes.
Now, towards the bottom of that page, you also will find a chart. What was the query and what is it? What is the response? First query, bidder to submit the certificate in name of so-and-so issued by practicing cost accountant or practicing chartered accountant regarding local content as per annexure 9A of ATC of bid document. And what is the response? Bidder submitted a certificate dated 17/8/2024 issued by so-and-so. Now, second query, bidder to submit the clearly readable copy of partnership deed of so-and-so. Bidder submitted a clearly readable copy of partnership deed of so-and-so. Third query, again, it is reproduced and response. Bidder resubmitted the copy of the working capital certificate. Evaluation of documents submitted by so-and-so online and submitted document after technical clarification and observation of TC as follows. And accordingly, we have made the observations. If your lordship will kindly turn to 495, the entire bid was once again re-evaluated. $495 is the Make in India document towards the bottom, and your lordship will kindly note the observation. As the document of local content submitted against the clarification is dated 17/8/2024, that is of date after the bid submission end date, bidder does not fulfill the eligibility criteria as per requirement of bid document. Next, again, legal status of bidder. Observation. The submitted document regarding consortium agreement is not in line with the format provided at annexure 2 of ATC of bid document. Therefore, the bidder does not fulfill the eligibility criteria as per requirement of the bid. And thereafter, at page 498, this is the ultimate conclusion. On the evaluation of the document submitted online, TC observed that the bidder so-and-so, bid submitted by so-and-so, in fact, does not fulfill the eligibility criteria as per requirement of bid document. And thereafter, the bidder who was found to be otherwise eligible, tender committee did not proceed to open the financial bids. It is only after re-examination of his uploaded documents that the tender committee recommended. Towards the bottom of the page, your lordship will find Mahalakshmi so-and-so. Accordingly, tender committee recommends obtaining approval for opening price bid of Mahalakshmi as per so-and-so, which reads as under. And then, even then, he again submitted a representation. There is a procedure prescribed for consideration of the representation. That your lordship will find at page 501.
Yes.
This is the procedure prescribed. And if your lordship kindly turns to 502, clause 5 provides as to how these representations are to be considered. Any document submitted by seller through challenge rejection window shall not be considered other than application uploaded as appeal. And we treated his representation as an appeal. And the tender committee once again met to examine his representation and appeal on 26/8/2024, which your lordship will find at page 503. And your lordship will find that now in the writ petition, a plea is sought to be developed. That part of the page was not readable or something. It was not available. That plea was never taken in the representation of the appeal. It is for the first time that this point has been taken in the writ petition.
So the appeal is page,
Appeal is in their writ petition. What is it? It is at page 206. Your lordship may just make a note that this something was not readable or not available in the website or something. That plea is totally absent in the appeal. This is developed for the first time here. Now, how the appeal is considered is at page 503. And your lordship will find, I am not troubling your lordship by reading the entire document. Your lordship will find that it runs into 5 pages. Detailed consideration of speaking order. And that is why I said none of these are under challenge. The recommendations of the tender committee are not under challenge. The consideration of his appeal and rejection thereof is not under challenge. On 26/8/2024, the appeal was considered and rejected by passing a reasoned order.
26/8/24. Appeal rejected.
Appeal rejected. Thereafter, the financial bid opened on 30/8/2024. And without challenging all of this, a repetition is filed, merely challenging his rejection. Even the other part of the evaluation is not even questioned, only his rejection is challenged. And there is an interim order because of which we have not been able to pass the final, issue the final vote. Now, this is so far as the decision-making process is concerned. Now, coming to the law, your lordship is already aware. I will quickly brush through the judgment. My first submission is that in the context of the specific role assigned to the tender committee, because here is a tender document which casts the entire responsibility on the tender committee, and that recommendation is virtually binding. And those recommendations are neither under challenge, neither is the tender committee made a party, nor is any malafide alleged against any members of the tender committee. These are 3 very vital aspects.
One was that the recommendation is not under challenge.
Recommendations not under challenge. His rejection of appeal not under challenge. Tender committee not made a party is third. No allegation of malafide against any member of the tender committee. So these are the 4 subcategories on which I am questioning the petition itself. Now, everything is uploaded on the websites. On 30th of August, the tender committee had already opened the financial bid and made a recommendation in favor of the respondent number 6. That is not even placed before your lordship in the petition. And the interim order is pressed for on 6/9/2020. Whether that would amount to bona fide conduct.
We'll take it up after lunch.
I'll take hardly 5 minutes.
I've got a meeting to attend to that.
Fine.
Can I reply tomorrow, lordship? Or maybe on Monday?
And, look, actually, we have got to try and complete it. We can do it tomorrow.
Or maybe whatever is convenient.
We can try. No guarantee because the other matters are here. So
In
you
that case- in
you
that
take
case,
5
your
minutes. You complete your 5 minutes. I'll hear you for 5 minutes.
Or else I can do it because I'll have to place the judgments also.
So you won't take 5 minutes.
5 can stretch to 7 minutes.
Indian stretchable time.
That much of liberty because my learned friend took.
I know. No,
1
no,
hour.
because you are not going to complete. I think Mr. Ken Chaudhary also will be.
Yes, he is
Bring
there for the
submission.
private respondent.
So.
In that case, let it be on Tuesday, my lord. Because I have in between, I have to be in Itanagar.
Which matter?
Tuesday.
Huh?
Tuesday, your lordship, and it will take hardly how much longer. I don't
No,
think.
no, you have said so many things. By the time Tuesday rolls along, I'll forget more than 90% of what you have said.
We are,
That's what I'm worried. The thing is, the retaining capacity of our mind is not that good. No? So we've got to, that is more my worry actually.
tomorrow and Monday, actually, I'm in fact heading straight to Itanagar.
Oh. Yes.
Tuesday would have been Tuesday, Thursday, Wednesday, any.
Thursday we have no chance.
Let it be on Tuesday.
Thursday we have got big matter. Long matter, not big matter, long matter. So, okay, we'll try on Tuesday. Only thing is that what you all can do is your citations. If you all can make it, give me the
what I'll-
paragraphs and,
What I'll do is, I'll take a printout of, make a compilation
yeah,
and give the page numbers at the top.
correct. The page number, the paragraph number.
Yes,
So that'll be easier.
yes.
We have made already an index.
Okay, already made.
In that case, your lordship is not taking up at 2 o'clock.
No, I guess not, because you all are not going to finish.
Yes, yeah.
I don't think you all are going to
Tomorrow,
finish.
Tuesday, maybe just
Um,
today, Lord.
Tuesday we'll
The
try and
only
finish.
difficulty is, my lord, we have the bid validity is expiring. Your lordship will have to make an observation that it has to be extended.
Bid validity, I think you can extend bid validity.
There can be extended interim order, maybe also extended.
I think.
Your lordship can make an observation that the bid validity
When is it expiring?
on 3rd.
Okay. Who is for the private respondent? So are you willing to extend their bid validity? Huh? Okay, for another month or what?
I
Till
don't think that
disposal.
it will take that much, but
No, might
to
take.
be on the safe side, your
There are
lordship,
said so many things. Right. Okay. I heard Mr. D. Saikel, learned senior counsel for the petitioner. And Mr. M.Z. Ahmed, learned senior counsel for the respondent number 5. Also heard Mr. I. Chaudhary, learned senior counsel for the respondents number 3 and 4. He's not here. Mr. N. Gautam appears for the respondent number 6. Mr. D. Saikia, learned senior counsel for the petitioner. And Mr. N. Gautam, learned counsel for the respondent number 6, submit that they do not have any problem in extending the
bid validity.
bid value,
Validity.
the validity of the bid submitted by them till disposal of this case.
Yes, that
Till
will be
disposal
separate.
of. Accordingly, on the prayer of the counsel for the parties, list the matter on 3rd.
The interim order may be
Interim order to continue till the next day.
Bid value.
Put it anyway.
Why not
Yes.
kindly fix the matter on any day? We have missed in the cost list, lordship, because our name was not reflected in the cost list.
Name of Mr. Ardhar may be reflected, my lord. The last occasion.
You have got to make some treatment application.
Yes, my lord. Government of India.
My lord. There is
They have to
no
release the
such
fund.
order, my lord,
They have to release the fund.
because it is not, my lord, earlier date, my lord paid the amount, my lord, 50%. The respondent number 2 has paid the amount, so now, my lord, it is the respondent number 2 who should pay the, my lord, balance amount, my lord. It is not a concern from where they will get the amount, my lord. Earlier they paid, my lord.
The fund is to be provided by the chairman cum managing director NSFDC as per their affidavit.
Paid.
But now their source of money has dried up. No, that is what they are saying. I know it depends upon you, right? Miss?
Toshi Sinha.
Toshi Senla appears for Mr. S. Datta,
No, Mr. Arthur
Mr. Ardhar, counsel for the
is respondent to S.
point number 2. Full stop. Para 5 of the affidavit, the position filed by the respondent number 2 states that in the context of making payment to the petitioner, it is the chairman managing director of NSFDC, New Delhi, who is to provide funds for implementation of the training program. Full stop. However, the said chairman managing director NSFDC is not a party in the writ petition. So what do you want?
Mr. Arthur's name to be reflected in the cost.
Okay. This is a matter after 2 weeks. Registry to reflect J. Ardhar, correspondent number 2. Seventeen? I didn't. Okay.
Lordship, in this matter, we have received some instructions. I'm not privy to those instructions, as these instructions are with Council B. Google.
So
Lordship,
he's
on legs.
coming.
He's on legs, Lordship.
Okay, we'll wait for him.
Okay.
Next. There's a review petition.
Yes,
What's the
has
pendant?
been already disposed of by this honorable
Huh?
court. Review has been already disposed of by
Disposed.
this.
How? Dismissed?
Dismissed, Your Lordship, but there is one observation that it is the duty of the petitioner to implead Jal Shakti. If they have not impleaded it, they will.
But how
face the
can they
consequence.
implead in the contempt?
But Lordship, we have filed a review for implement of the Jal Shakti, Your Lordship, but the honorable court observed that that cannot be done because they had to do that at the initial stage. If they have not, the consequence will be faced by them. And we have filed our affidavit in contempt petition also, Your Lordship.
Huh?
Where we have filed our affidavit in the instant contempt petition, Your Lordship. Lordship, we stated that we have already forwarded the monitoring status to the.
Yes, madam, what to do now? You have to wait for the other writ petitions, I think.
Yes, Your Lordship.
Otherwise, you see, you could have impleaded Jal Shakti.
I will be filed and I will implead the Jal Shakti.
Where? Not in the contempt. How can you file in the contempt? You'll have to maybe file a review of the order with the application to implead Jal Shakti. Then that's the only way out. है ना? Miss Diangana appears for the petitioner, while Miss Ardeka appears for the respondent. It has been submitted at the bar that the review petition number 191 of 2024 has been dismissed by an order dated 20/11/2020. On the prayer, the parties list the matter after 2 weeks.
Obliged.
5 to 9.
My lord, contempt petition, my lord. My lord, last occasion they have submitted that a report was called from the DC. And thereafter the affidavit has been filed, my lord, on another plea, my lord. There,
Huh?
another plea was taken in the affidavit. They have stated that the Assam State Disaster Management Authority approval is required. But it is not, they have not taken this plea during the petition or earlier, my lord. Now this plea has been taken.
Come to the last line, page 20.
The proposal submitted by Senator under process release a fund for in terms of the order dated and will be released
Within 8 weeks.
after 8 weeks.
Right.
Can it be a shorter, my lord?
Huh?
4 weeks, my lord. 4 weeks.
This is what they have said. How will it matter, right? As per the affidavit filed by the respondent number one, the process for release of fund to the District Commissioner Karimganj and the subsequent release of the same to the petitioner is completed to be, is expected to be completed within 8 weeks. Accordingly, leave this matter. When? After the vacation. After the vacation. After the vacation, huh? Then what about in the other contempt, you have not filed affidavit?
All are similar, some same scheme laws.
Okay, next you write, Mr. S. Data
Except 9 we have not received any,
submits that submits that the affidavit filed by the respondent number one in contempt case 375 of 2024 shall also pertain to serial number 678, huh? 678. However,
9 is also same.
However, Mr. S. Data submits that he has not received any instructions with regard to with regard to contempt case number 534/2024.
9 most probably, service not completed. That's it. We have not received any notice.
Give me
Nine.
that item 9.
We have no instruction like that. Same order, date to order.
As per office note in that item 9, huh? As per office note dated 26/11/2024, there is no return of AD card or unserved notice from the sole respondent. Petitioner takes fresh steps for service of notice upon the sole respondent by registered post with AD within 3 days. List the matter after the
Time being item 70. Regarding the representation.
Huh?
There was a representation submitted by the OEM of the petitioner. Regarding that, it was submitted in GEM portal. The tender process was initiated. Now it's difficult to find whether it is there or not. They say that if there 10 days time is given or say some reasonable time, they will reconsider it on this particular SIM law. If it
Okay.
is turned down, it's.
Okay, Mr. B. Gogoi, Learned Counsel for the SSA submits that the respondents will consider the representation submitted by the petitioner's OEM within 10 days.
My lordship will indicate the date, 4/3. The representation dated 4/3,
And the petitioner's representation dated 4/3/2023.
24.
4/3/2024.
After 10 days.
Accordingly, release this matter.
My lordship will give direction for them to consider. It will be considered.
Accordingly, the respondent, the state respondent.
Yes, the SSA.
Huh? Accordingly, the respondent SSA shall uh, uh, take a decision on the representation made by the petitioner's OEM within 10 days,
More particularly on the SIM lock part. Otherwise,
comma, and more particularly on the SIM lock
yes.
to be, that is required to be installed in the PC tablet. List the matter on.
Perhaps the earlier interim order needs to be continued.
Huh?
Earlier interim order needs to be continued.
Interim order to continue to the. Just read the clear thing. Listen, As it submits that the respondents have not taken a decision on the representation dated so and so submitted by the petitioner's OEM. Till date, as the representation is not traceable
Yes, in GEM portal.
in the GEM portal
Right.
as on date. Then
But can it be a 12 or 13 months?
when you want?
12 or 13 months?
Okay, 12.
Month. Problem. Lordship, in this matter, like I was supposed to file an affidavit along with the like department's liability. Lordship, I have received some information, Lordship, I could not prepare the affidavit. Last 1 week, I was busy with some personal issues, Lordship.
So when did you file?
2 weeks time, Lordship, I can. Like, actually, Lordship, what has happened is that the instruction I have got is that, I mean, that there were 2 periods were there. Actually, from 1996 to 2007 and 2007 to 2014. So our liability, as per the commissioner's report, the same liability will be there, and like that liability already paid. So the only thing is that like whether this from 2007 to 2014, whether that we have to pay or not, that is the issue. I'll just clarify with an affidavit. Lordship. 2 weeks.
Mr. A. Kalita, learned counsel for the petitioner, submits that he has received instructions and he needs clarification with regard to whether the petitioner is liable to pay the salary from.
That may
Third-
not, may not be required to be recorded, Lordship.
Okay.
Only thing is that like.
So
2 weeks
submit that he needs further clarification. He has received instructions and needs further clarification. Which he wants to submit by way of an affidavit.
Lordship.
List the matter on. Okay, no, just say, the petitioner shall submit his affidavit within 2 weeks. List the matter after 2 weeks. Okay.
Oblige.
Lord, this matter was substantially heard. In fact, on the last occasion, I had concluded my argument and the Lordship has recorded my submission. And it is for the respondent who was supposed to. This begins.
Just a minute,
The
just a
order
minute.
dated 12/11.
Just. Yes.
So far as we got that compliance of order 580.
Huh?
He has raised a we got point
Yes.
that or compliance of order
5 rule 18.
518
Huh.
because service report is
No service report.
yes, we got. To my submission, we got. It is not required. It is not required because the Industrial Dispute Act and rules made thereto has provided certain provisions, my lord. If your lordship come to, my lord, Rule 18,
Rule 18 of the.
Rule 18 of the Industrial Dispute Center Rules 1957, my lord.
Yes.
Married, my lord. Service of summons or notice. Subject to the provisions contained in Rule 20, any notice, summons, process, or order issued by a board, court, labor court, tribunal, national tribunal, or arbitrator, empowered to issue such notice, summons, process, or order may be served either personally or by registered post, and in the event of refusal by the party concerned to accept the said notice, summons, process, or order, the same shall be sent again under certificate of posting. Look, specific provision is there regarding service of notice. It does not say about submission of any service report, my lord. Rather, it has gone against the spirit of the CPC, my lord, that order 5.
No, this does not say anything.
Yes, my lord. I'm coming to that. Again, my lord, kindly come to Rule 24. Kindly come to Rule 24.
Yeah.
Power of boards, courts, labor courts, tribunal, and national tribunal. In addition to the power conferred by the Act, boards, courts, labor court, tribunal, and national tribunal shall have the same power as are vested in the civil court under the Code of Civil Procedure when trying a suit in respect of the following matters.
How
named-
does it, how is this got any relevance?
Because this very Act has said that only on these three matters, the CPC is applied. Regarding what? Discovery and inspection, granting adjournment, reception of evidence. Only in these three aspects, CPC will apply. And for notice, service of notice, that will not Rule 18 is clear. Now, my lord, even if it is found that CPC is applied, then, my lord, the CPC, my lord, Order 5, Rule 9 speaks about issuance of notice and how it is to be served, my lord. Kindly come to Order 5.
Yeah, talk about the proviso.
Not, my lord, not proviso.
The proviso to sub-rule 5 of rule 9 of order 5, I think.
No, not proviso, my lord. Sub-rule 1. Sub-rule 1.
Order 5.
Order 5, Rule 1, sorry, Rule 9, Sub-rule 1.
Order 5, rule 9. Yes.
Sub-rule 1, when the defendant resides within the jurisdiction of the court in which the suit is instituted or has an agent resident within that jurisdiction who is empowered to accept the service of summons, the summons shall, unless the court otherwise directs, well, court otherwise directs, that is important, be delivered to send either to the proper officer, here, my lord, process server, to be served by him or one of his subordinate or two such courier services. Now, otherwise direct. In this case, in the present case, the tribunal, labor court has sent the notice by deputy special messenger, not process server. My lord. So, my lord, Rule 18. Rule 18 speaks about when it is serving officer, means process server. But in this case, there was a messenger of the court, my lord.
Where is the messenger's report that it has been served?
That is not given in the CPC, that when messenger or otherwise, when the court directs otherwise, that in that case, service, report has to be, submitted. Service report has to be submitted, my lord. That is not there given. And, my lord, when, my lord, specifically deals with Industrial Dispute Act, specifically deals with that matter. And more particularly, when it is says that in the event of refusal by party concerned to accept the said notice, summon process order, this same shall be sent again under certificate. Whereas CPC says, my lord, if somebody refuses, then it will be deemed to be served.
So where is the refusal here?
No, refusal is not there. What I am trying to say, my lord, this particular rule is deviated from the CPC, my lord, that order 5.
What rule?
There is a deviation, my lord. That, whatever the spirit of the order 5, that has not been followed here. That I am trying to say, my lord.
I am lost. Thoroughly lost.
And more particularly, my lord, when Rule 424 says only in 3 aspects that CPC will be applicable.
Anything else?
Secondly, my lord, from the
So according to you,
my lord,
No service report is necessary,
necessary.
not,
Because-
not
because-
required.
As per the special act, Industrial Dispute Act. It's,
Where is the finding by the labor court
yes,
that, that the respondent has been deemed to be served the notice? Where is the finding by the labor court? Is it necessary to have a finding by the labor court that notice has been deemed to be served?
that pursuant to order dated, Milord, 9/6/2000. Record, I have to see record, Milord.
No, you see,
Yes.
sure.
Yeah, deeming provision is not there because they have signed it.
Who has
They have
signed
sealed
it?
it and signed it.
Who has sealed it and signed it?
The company, Milord. That management.
Where? Show me that document where they have sealed it and signed it.
Yes.
Page
In their petition itself, Milord. As paid for 46, Milord.
Page 46.
46, Milord.
There are two seals, my lord.
Ah,
There are two seals.
ah,
Two seals and
Ah.
one signature
ah.
is not legible. That is why it is more important for the process server to give a report that so and so belonging to such and such company has received the notice and it was delivered on such and such time on such and such day. So here, this one seal, Assam Roadways Limited. The other seal, which has a small, which is visible, that is private. So there are two seals. And who is the person who received? And if your lordship goes to the notice, the management of South. So my lord, management, it has to be either the manager or the director or someone. Notice has to be served. The management of,
I don't know. No, where does it say management?
lordship will see. This is the notice, page 46, then copy 2. First, present so and so labor officer, management of so and so, reference. This is what is indicated as per order dated 9/6/2014. You are hereby asked to appear before this court on such and such for return of notice and filing of written statement either personally or through legal representative. And then copy to management of South. So the notice must be, if it is delivered upon the office, the special messenger, whatever he is, must at least give a report that such and such person in such and such office has received and I have delivered him the notice which was received by him on such date at such time. Nothing. There is no report at all.
It says there, the workman is present, notice issued to the management has been returned after service.
Yes. Now that is an order of
21/6.
21/6
Ah.
after service.
After-
Now, on that day, on 21/6, the court did not proceed ex parte. Court did not proceed ex parte. Court proceeded ex parte later on. And on the day, my lord, there was no report from the special messenger that yes, I have gone there, I have served it upon such and such person of the management.
Okay,
Right.
okay, leave it, supposing supposing is deemed to be served. Now the second point, the basis for the labor court to come to a finding that you are the workman of the petitioner
Yes,
is that receipt,
yes.
only that
No,
receipt.
not receipt. Milord, other things are there. Kindly come to exhibit 1. That's my evidence.
No, show me the judgment, in the judgment, what is the finding? I'm not going on that. Show me the finding of the letter.
Finding here, finding is there inside.
What is that?
Yes.
Lordship will find at
Where
page
it will,
29.
at page 29.
Page 29.
29, Milord.
Yes.
Workman, so-and-so W1, in his evidence has reiterated what has stated in his evidence. According to the petitioner workman.
No, don't go on this. I want to know his findings. I don't know. I don't want to see what has been done. What is his findings?
6, paragraph 6.
Yes.
I have perused the evidence of WW1 and gone through the
Exhibit
documents.
4 also, Exhibit 3 also, my lord, perused.
Now,
Exhibit 1, 2, 3, 4, all exhibits were, my lord, perused.
What is exhibit 1?
One is a money receipt. Let me explain, my lord.
What is the money receipt?
that your lordship will find at page 48.
Page 40.
My lord, originally it is in the, my lord, record.
Okay, this is by the petitioner received from HPC, nothing to do with you.
My lord, I'm showing you that. Because this petitioner has received this money on behalf of South Assam Roadways.
From where do you have?
That itself it says that.
How do you prove that?
My lord, that is, if your lordship says that you prove the things beyond all reasonable doubts, then yes, of course. But in a tribunal, my lord, because this is circumstantial evidence, this is circumstantial, my lord. At second, my lord, just below, my lord, kindly come to the exhibits. Kindly come to the exhibits. They have hidden one, my lord, document. Where is the lord? But in the exhibits, my lord.
Mr. Counsel, I am the one who's asking questions.
My lord.
Okay.
My lord.
This para 6 talks about exhibit 1. What is this exhibit 3?
Exhibit 3 is the complaint, my lord.
Complaint.
Yes.
Complaint.
Complaint means I have written to the labor inspector, my lord.
What is exhibit 4?
Exhibit 4 is the notice sent to them by the labor commissioner.
So how do these documents prove that you are a workman?
Yes, my lord. Exhibit 1 and the other page of the exhibit 1, my lord. Kindly peruse that one.
That page of exhibit 1.
Exhibit 1
only.
And my lord, I am the member of my union. My union has also supported me.
Maybe.
That letter has been there, my lord. Kindly peruse the.
There is no finding by the labor court that you had received this exhibit 1 on behalf of the petitioner. Where is the finding of the you just said that you had received the receipt on behalf of the writ petitioner from some XYZ.
Yes.
Where is the finding of the learned labor court that you had received exhibit 1 on behalf of the writ petitioner?
But that exact finding is not there, but after perusal of the entire document, he has come to the finding that he is a workman, my lord.
Okay.
If your lordship kindly peruse the exhibit 1, my lord, that is in the, my lord, record, my lord. Exhibit 1.
Yes, I've got it in front of me. Yeah, this page 48.
Yes, below down that, my lord.
Yes, below down what below down?
No, that is the, my lord, writ petition, their writ petition, my lord.
Yes.
In the case record, my lord, the LCR. In the LCR, my lord.
It's the same thing, same document.
Yes, that document is there. Also, one document is there, my lord. That is at page, my lord, page 8 and 9, my lord, of my evidence, examination in chief on evidence, affidavit. At page 9.
There are so many page 9s. Okay, I've got it. Yes.
Of my evidence on affidavit.
Exhibit 1 out here is something else. Out here it's exhibit 1 is a copy. What is this? Is a letter.
That is,
I'm sorry, lord.
the lordship will have a look at the evidence in affidavit. This letter which my friend is referring, is not even exhibited. if your lordship goes to the
Ah.
evidence on affidavit, that is the affidavit,
It is not exhibit.
paragraph 13 has given the list of exhibits in the evidence on affidavit. Paragraph 13, the
Paragraph,
documents relied upon
paragraph 13
of the evidence in affidavit of the workman.
where in this,
It is not there, perhaps it will be in the record.
it just says EX 2123, there's nothing here, no
Yes,
signature,
there is-
nothing.
he has referred to 4 documents, the list of exhibits. Perhaps if the lordship provides me the record, I'll be in a position to find it out.
Order sheet, order of case,
It is-
just give it to him. Ah,
File আছে নাকি?
you can give this.
This is the evidence in affidavit filed by the workman Lalan Chaudhary before the labor court. And paragraph 13 and page 6 of the affidavit, he has described the document he is exhibiting,
Who is Lalan Chaudhary?
the concerned workman. Paragraph, the documents relied upon by the petitioner are filed as exhibits as follows.
Where, para?
Paragraph 13, page 6.
Yes.
He has relied on 4 exhibits. Number
Yeah.
1, exhibit 1 is the original copy of the bill challan received by me for and on behalf of management of so and so as proof of my service. Original copy of the complaint, exhibit 2, exhibit 3 and exhibit 4. And this exhibit 1 is that page 48 document.
It is here, this one.
Yes, no, the exhibit 1.
It says the exhibit 1.
There is a bill challan which we have
Correct, the same bill.
we have also enclosed.
Yes,
that
yes, that's the same one.
48.
It is here.
So that is the only exhibit on the basis of which he is saying that I am an employee under the management.
Because he received it on behalf of you.
Ah.
That's what he said.
But his case is he has received on behalf of the management. Labor court's finding is that he has received this much money from the management. If your lordship takes up the finding of the labor court, how labor court has read exhibit 1, paragraph 6, exhibit 1 would show that he has received that much money, amount of so and so by bill number from the management. So his case is, I received the money on behalf of the management. Labor court goes further. He say, labor court records a finding that this money he received from the management. And on that basis, labor court has come to a finding that he is a workman under the management and nothing else.
And
There was no other exhibits.
down below that, I have red flag, my lord.
Red
Flag
flag.
in red, my lord. Yes,
Yes.
Is the letter,
yes.
officer in charge.
Officer in charge.
Now,
Yeah.
this document is not exhibited, my lord,
Not exhibited.
not exhibited.
Exhibit 1, that is 1 and 2, my lord. That pagination was done 1 and 2.
No, this is only one.
It is only one. Two is the
My lord,
original copy of the
I'm not
contract.
talking about exhibit 1. Yes, page 1 and page 2, my lord.
Page one, page two, okay.
Yes. So this is a part of exhibit 1, my lord.
No, no,
No,
part
well,
two, no, no,
continuation
sorry.
of exhibit
No,
one.
no, no.
This is the.
One is
absolutely
the
misleading
receipt, one
statement.
is the receipt, and one is a letter to the officer in charge.
In
This
fact,
is not part.
There is no description of that letter in the, in
Correct,
paragraph 13.
correct. It's not,
So it is not part of the record and cannot be treated as an exhibit in the proceedings of the labor court.
But
Correct.
ultimately that was brought by way of
Huh?
affidavit. That was brought by way of affidavit.
maybe you brought by way of
And
affidavit
that
doesn't,
itself,
doesn't change the fact that it is not an exhibit. Doesn't change anything.
from the exhibit 1, 2, 3, from the entire perusal mirror, it shows that I am the employee of him.
Labor court has given his own findings, which is not as per your submission. Your case is that you had collected this money for the management. Labor court has however held that the management has given you this much money. That's all.
That observation may be wrong, but ultimate finding is not correct. That is-
No,
that-
ultimate finding is wrong. It's not an observation, that's the finding.
Because if I am not a, yet, then how can I?
You can go to division bench and correct that. There's always, liberty is always given to you. You can, because my understanding of the English language is, when you say that you receive money from somebody and another person says that says something else, it doesn't mean the same thing. When I say I have received money from so and so on behalf of so and so, and the court says, no, you did not receive from, you received from so and so for yourself only. That's a different thing. It's not the same thing.
Because so far as, okay, no doubt, this finding may be there. For decision of this finding, if your lordship may set it, but not setting aside the ex parte method. Maybe, a hearing will be there,
I
But
have to
because-
set aside the ex parte.
of course, otherwise.
Actually, I have to set aside everything.
No, set aside, not ex parte method.
I will send it back.
Yes, but that ex parte will remain with us.
No, no. Sorry. No, nothing. No ex parte cannot remain. Everything will go. know,
Because of non-submission of service report.
Because of the judgment itself is wrong.
The judgment is wrong, that is one thing, my lord.
Uh,
But that aspect, whether it was served or not, that aspect,
I will pass the judgment.
of course,
and
of
then
course.
you see.
of course.
Okay, right.
And we will do one more thing, that regarding 10B, rule 10B.
10B, yes. What about 10B?
Regarding 10B, my lord, this is when both the parties appears, my lord, because similar provision is there in the, my lord, post rules, my lord. Kindly come to rule 22. And 22.
Okay, doesn't matter. Can do that. So it says here the labor court will proceed as if the party had duly attended.
Yes.
So, what is wrong?
What he has said that, Rule 10B was not complied with.
This is only with regard to the first sitting, Mr. Counsel. It does not refer to the subsequent sitting. Correct. Mr. S. Sahu, the learned counsel for the respondent number 2, submits that there is no requirement for a process server to give a service report that the notice issued by the labor court had been served upon the writ petitioner, prior to the labor court proceeding with the case ex parte, the petitioner. First, he submits that in terms of Order 5, Rule 9 CPC, he submits that Order 5, Rule 9 CPC does not provide for such a situation. He submits that an ex parte proceeding can be made, even if no report is made by the process server.
As the notice was served through special messenger, through special.
Come in as much as notice was served upon the writ petitioner by special messenger. Gustav. The counsel for the next paragraph, counsel for the respondent number 2 further submits that the Exhibit 1, EXT1, which was a receipt for money paid by HPC/CPM Panchgram Assam to the petitioner, was received by him and subsequently paid to the petitioner. Full stop. The same proved that the respondent number 2 was a workman working under the petitioner, and the learned labor court has rightly referred to Exhibit 1 as proof of the respondent number 2 working for the petitioner. Full stop. He also submits that Rule 10B of the Act is not applicable. What? Rule 10B of the rules. Rule 10B of the industrial dispute bracket central bracket close rules, 1957, hereinafter referred to as the rules, is not applicable to the facts of the case. But
deals with in a situation where both the parties are present.
Deals with a situation where both the parties are present. As such, the subsequent non-appearance of the petitioner before the labor court justified the order passed by the learned labor court proceeding with the case ex parte the petitioner. That's all.
One more. Regarding service of notice, I have two arguments. One, because of Rule 18, when it specifically deals with a procedure. That is why Order 5, Rule 18 is not applicable.
Rule 18 of what?
Industrial dispute central rules.
Rule 18 of. Rule 18 specifically deals with.
He also submits that as Rule 18 of the rules specifically deals with service of summons or notice of the summons or notice to parties, comma, the provisions of the CPC would not be applicable.
Not be applicable because we know
Would not be applicable with regard to the issue of the process server requiring to submit a report regarding the service of summons to the opposite party. Next part. I have heard the learned causes for the parties. Huh? Rule 18 of the rules states as follows. A perusal of Rule 18 shows that subject to the provisions of Rule 20, any notice issued by the board, court, labor court, tribunal may be served either personally or by registered post. And in the event of refusal by the party concerned to accept the said notice, the same shall be sent again under certificate of posting. In the present case, there is nothing to show that the petitioner had received the notice by the. What about your seal? The small seal is there.
My lord.
In your writ petition, that in that notice, that seal is there.
So there are two seals.
Hmm.
That is why, and there is nothing to show who has received it. That is why we are insisting that it should come. Otherwise, also, if your lordship strictly goes by Rule 18, then the notice even is not in as per the form mentioned in the rules. Lordship will have a look at the form of
What have I
notice.
said? What have I said? Now, in the present case, there is nothing to show that the petitioner received the notice in as much as there are two seals in the notice dated 9/6/2014.
on that aspect, he was cross-examined.
Huh?
On that aspect, he was cross-examined
Cross-examined by who?
regarding the two seals.
Then
He said that this is not my seal.
seal.
You know, cross-examination, he was asked whether you have brought your seal. He did not brought. In cross-examination, he's
Anyway. Okay, just say. We'll just say the judgment reserved. I'll pass the order later. It will take time.
Abla-
obliged.
Yes.
I am appealing for the respondent one, Lordship. Lordship, they are basically challenging the order passed by the Union of India, Lordship, for which the Council Sukumar Sharma was appearing, Lordship. He earlier on 7/11, he informed the Sonabur court that he will be out of station from 2011, Lordship, due to his health issue. On 9, that's why Lordship has fixed the matter on 19, but on that day, matter not reached, Lordship.
So,
He informed us that he is already out of station, Lordship.
okay.
Next week.
Right. On the prayer for adjournment made on behalf of Mr. S. Sharma, learned CGC, list the matter after 2 weeks.
I am for respondent one.
Mr.
K. Kolita.
Before that, Miss
Vidas.
B. Das appears for the petitioner, while Mr. K.
K.
Kalita appears for the respondent number 1.
Hello.
Petitioners, petitioners. Okay.
15 and 16.
Yes,
This is ready for hearing, otherwise this will be going for the hearing, because there was a issue about a application that was filed for an interim that is all being set aside. Now we'll be hearing the main matter. So there are two writ petitions here. The first one is 4030 and the second one is 4811. We'll be sticking to 4811 because that's the second writ petition. All the facts has been substantially covered in this.
how long will you take?
He will take time, but minimum.
Because I have to rise at
Yes,
3:15.
just inform that you.
Yeah, I've got a, again, interview.
Yes,
Kind of things.
I'll take a little bit of time. 15, this code is right.
15.
Yes.
Can you finish?
No, madam, this will take time because this is for termination of a contract also.
Blacklisting?
Sorry,
Any blacklisting? No
no
blacklisting.
blacklisting.
So contract terminated and
First
someone
petition is-
else has been doing the job.
That I don't think they have appointed anybody. What happened is there was first a demand notice against which we came to the High Court saying that we have not been heard. That was one writ petition, and interim order was passed. Subsequently, after that, my contract has been terminated within the span of 14 days. So I came here for the termination also. So both the matters are listed before your lordships.
There's a recovery
So there's also a recovery that has happened in the
recovered.
first matter. So
Huh?
Because he will take minimum 1 hour, madam.
Okay, then let's take it some other time. What is this construction of what?
bun guide.
Huh?
Bun guide. This is on the railway platform. It's a construction of a bun guide which actually takes an extension of the railway platform, existing platform.
Right, let this matter, when,
Was suggesting to my
Do
lord, if it could be on the first week of January, sometime he said 9th, if it is not inconvenience.
No,
That's a Thursday.
other courts have got 2025 calendars.
May 2024 is same, madam.
I know, May,
Suggesting a Thursday if it is not inconvenience.
9 is holiday. No, not.
9th is not a holiday.
Yeah,
It's a working extension. Okay, right, on the prayer, the parties list the matter on 9th.
Extremely great.
My friend always want to argue before this honorable court is case.
Why? Huh?
3 times listed before his honorable.
I know what to
Slightly
do.
unfortunate. It's been listing here.
Very, no, what to do. Actually, this whole week we have been having
Yes.
interview also.
Otherwise,
then-
we had time. We could have.
And no, this morning's item took too long.
Yes, I don't want
The
to
whole-
long.
yes.
We thought that today it will be completed because, but I don't want to time.
Item one took too much time.
Yes.
Otherwise,